criminal misdemeanor cases in which individuals have already been arrested and or been charged with one or more misdemeanor offenses. The cases most of the cases have already bond set in them, and they have been with the state court system for some time. Today, this is what we call our Orca final plea calendar. Most of the cases were scheduled here today with the intent to take a final plea, in other words, a plea hearing in which the defendants intend to enter a guilty or no contest plea to the charge or charges brought against them. If you are a defendant appearing on Zoom or a defendant appearing in the courtroom, please remember that you have a right to remain silent. Anything you choose to say during the course of this proceedings, whether you decide to make statements either virtually or in person, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. At this juncture, when the cases are being set for a final plea, I hope most of you have already consulted with the public defender's office to see if you qualify for their services. Otherwise, you also have the option of hiring your own attorney. If you choose to represent yourself, please be advised that I cannot give you legal advice. At this juncture, I hope you've done the research or understood that any legal decision that you make, that you are responsible for the impact of that legal decision upon your personal status, whether it may have a negative impact upon any other open cases you have, whether it may have a negative impact upon any professional licenses you have or your current driving license, whether it may impact your residency, if it's applicable to your case or to your job, anything to that effect. All right? So I have a couple of cases that we have just postponed from our 9 o'clock calendar this morning. And that would be position number 1, Demetrius Batson. Ms. Rosenhuber, you are here on Zoom.
Yes, Judge, I am present, and I did get a chance to speak with Mr. Batson about his connectivity issues. He advised that he would at least try to get to a library if he couldn't get his phone to work. So if we could just hold, I know that he's trying to get on.
He could also come down to the courthouse.
I told him that as well, Judge. I did.
Okay, so we're going to hold for him. And then we have Mr. Griffin's plea in place. Is Mr. Griffin on the Zoom?
He is, Judge, and I have submitted that paperwork to ASG Riley as well as Miss Redden, I believe. But if there's anyone else that I need to send that to, I'm happy to do so.
All right, and I have Mr. Hamer Hodges, who's also appearing via Zoom.
Yes, and we are also ready to proceed with that plea. I did just send the signed paperwork back to Mr. Hamer Hodges so he could look at it, make sure everything was good. I did a lot of signing with express permissions, but we're ready on that.
All right. For our 1:30 p.m. calendar, I'm just leaping forward to position 18. Stanley Preston is present in the courtroom, and his attorney, Aaron Friedman. And Mr. Friedman, if you'd like to come to the podium, the microphone is right there so that prosecutors can hear you clearly.
Yes, Your Honor.
Go ahead and make your announcement.
Your Honor, we're going to request a jury trial at this time. We have received discovery. The video that was sent was not, it had bugs in it, but I will get with Ms. Reiser to fix that, but we'd be ready for trial.
All right. Ms. Riley, I'm going to generate a case management order today for this case, and it's going to be further notice for a jury trial. Anything to add, Mr. Friedman?
No, Your Honor. If there is motions, we will submit them after we receive that video. That can be heard right before trial. They won't be extensive if there is.
Ms. Riley, anything else to add?
Your Honor, I have positions 1 through 14. I'm not sure.
Ms.
That's
McCarthy?
okay.
Yes, Judge. No, nothing from the state. The offer was emailed on July 28th, and it's a first and lifetime DUI with the statutory minimum sentencing conditions as a recommendation.
All right. Okay, Mr. Friedman, you and your client are free to go.
That's okay. Thank you, Your Honor. And we'll have that 10 days to file after we receive discovery. It was sent on the 28th as well, Judge.
Okay. All right. Thank you.
Thank you, Your Honor.
Mr. Larry Korn, and you represent Miss,
Elizabeth Randall, number 19 on the calendar.
and if you'd like to go to the podium, is your client here, Ms. Randall?
She's not judged on this case. Is
Elizabeth Randall, are you on Zoom?
Judge, she is in ex parte status right now. I've submitted an order for an evaluation, and I'm just waiting to get that back.
When did you submit that?
Well, the motion was filed back in April, but by Mr. Raffoff. I didn't see where an order had been filed though, so I did that today.
Okay, so you've resubmitted the request for evaluation?
Yes.
I'm going to reset this case. And to whom did you submit the evaluation request?
Ms. Smith, S.M. Smith.
Okay, could you resend it to Miss Monica Redden, please?
Monica, yes.
Okay, and then it's going to be reset to the September 8th status calendar. And that's going to be at 9 a.m. When you say ex parte, the reason she's not here is because she's otherwise in a different location.
No, she isn't. There's just days where it's better for her not to be in court.
All right. Who is
I
that?
don't think I can put it any better than that.
Okay, Ms. McCutcheon, I think you can read between the lines.
Yes, Judge. The only inquiry the state would make with counsel is that counsel makes certain that the clerk of court is kept updated of the address and contact information to which to mail notices for the defendant.
I will.
All
Thank
right.
you, counsel.
Thank you.
I have all that.
You're free to go. Folks, if you are appearing by Zoom, as soon as you hear your name or your client's name, please unmute and verbally say present so that if I'm not looking up, I'll hear it and I'll know what to do. Same announcement for those who are in the courtroom. If your counsel, if you hear your client's name, please stand up and say present. If you are a defendant representing yourself, please make sure you stand up and say you're present when you hear your name, please. Raising your arm or simply nodding your head is just not going to do it. Is there anyone in the courtroom who does not understand English? Anyone on Zoom? Well, that would be difficult if you don't understand English. All right, so let's go with this. Position number 1, Benjamin Alvarado.
Here.
All right, Mr. Alvarado, who's your attorney? Who is your attorney?
Representing myself.
All right. And are you here to enter a plea today?
Yes, Your Honor.
Have you spoken to the prosecutor about what the plea offer is?
Yes.
Yes.
All right, Ms. Riley?
Yes, Your Honor. I have a note here from Ms. Reiser that the plea paperwork has already been turned in. I'm not sure
To whom?
that it does not say, but
Do you have a copy of it?
I do not. So I can, but I do have the recommendation and I can redo it if it has not been submitted. But that was the note that I have.
Judge, let me verify it wasn't sent to the state court.org. I may have it.
Okay, please hold on the paperwork. All right, Mr. Alvarado, we will take a plea in your case as soon as we get the paperwork to address it, okay?
Thank you.
Thank you, please hold. Milton Andrews, Milton Andrews.
Attorney Dr. Andrews.
I'm sorry, what's the attorney's name?
Terry Brock.
Terry Brook, okay, thank you. All right, Ms. Brock, and I see your client is present. How, so we're doing a plea today?
Right.
All right, perfect, thank you.
Your Honor, again, the same announcement that the plea paperwork was submitted.
I have it. I
You
have
do
it.
have it. Okay.
Unless I specifically ask for it, otherwise we have it.
Okay. Thank you.
I guess we're gonna null cross one of the charges as well. So Ms. Brock, Mr. Milton, please hold and we will take this up shortly. Courtney Bagley. Courtney Bagley. All right, Mr. Bagley, who's your attorney? Have you applied to the public defender's office?
I already played it.
Not in this case.
Yeah. I did a Zoom call last month.
That's right.
I played it, and for some reason, she reset it. I mean, she gave me what they. She would give me time to get a lawyer, but I already had played it.
Did you sign up on the plea documents?
No.
Okay, then you haven't entered a guilty plea yet. You have to review the plea documents, read through the questions. Well, we're going to send it today. Right. Ms. Riley, do you have the plea documents for Mr. Bagley?
Yes, Your Honor. I have that they were submitted via DocuSign.
Right. So we are holding on documents for Mr. Bagley. This is the other one that you have to resubmit. Antonio Cherry, Mr. Wilson. are you-
Yes, Your Honor, that is my case. Is Mr. Cherry present in the courtroom?
Yes.
All right,
Yes.
Mr. Cherry just said yes.
Okay, Judge, if we could hold on that, I'll report back.
Okay. Mr. Cherry, your attorney is Rosenhuber and she's on Zoom. Have you spoken to her?
Not today.
All right, at least you've spoken to her. That's good. Warren Doster,
Good afternoon, Judge. That's my case. Mr. Doster should be headed here in person. I believe that is going to be a plea, but is that Mr. Doster? Okay, Judge, I just want to announce pretrial, just to get the state to give me that plea offer, just to make sure we got the correct one, Judge.
all right, got it. Paul Elliott. Paul Elliott.
Good afternoon, Your Honor. Alan Lightcap for Mr.
Oh, he's
Elliott.
like it, yes, sir.
He's present in the corner here.
All right, and how are we proceeding on this case?
We've had a couple of different solicitors in this case, and I was hoping that I would have a little bit of time to discuss the particular mitigating factors in the case with Ms. Reiser a little bit more, but we've only just started our conversation earlier this week. If I could have a brief continuance of 2 weeks to another Orca plea calendar, I'm confident we'll know what we're doing in the case.
Okay, Ms. Riley, are you the prosecutor for today?
I'm sorry, Jordan Reiser is the,
Yeah.
did I say that? I'm sorry.
No, you
No.
did say Ms. Reiser, but today Ms. Riley is covering for Ms. Reiser.
Yes, yes, Your Honor.
Ms. Riley?
Yes, Your Honor, I do have the offer that was given by Ms. Reiser, but in terms of any negotiations regarding changing it, that would have to be done with Ms. Reiser.
Okay, I'm going to reset it to the next final plea calendar, which is September 8th. This is the final reset to the plea calendar, September 8th at 1:30 p.m. Again, appear in person, and if negotiations work out well, just make sure the plea paperwork is completed and it's sent to, well, send it to whoever and we'll eventually get them.
Thank you, Your Honor.
All right.
And may we be excused, please?
Yes, Mr. Likett, thank you.
Thank you, Your Honor.
And Ms. Likett, if you could file an entry of appearance.
Oh, I thought I definitely will. I thought I had, but thank you so much.
All right, you have a good weekend.
You too.
Daryl Ford.
Good afternoon, Judge. That's my case. I anticipate that being a resolution today. I just would like to speak with the prosecutor, so a quick pre-trial.
All right. All right, Mr. Ford, your attorney will speak to the prosecutor. You just need to hang on tight. Nigel Folks, Mr. Gator.
That is my case as well, Judge.
All right, Mr.
we,
Fultz?
we have a slight issue. The issue is I thought it would be on the calendar. I didn't realize that it wasn't until the last minute. Mr. Folks has 2 additional cases, and I have the case numbers.
Mhm.
And I think it'd just be better if we handled all 3 together. I can give you each case number.
Please do.
22 CR 005-846G.
Mhm.
And then 22 CR 000-129G.
All right. Ms. Riley, has there been an offer made for Mr. Foltz?
Yes, Your Honor. I'm sorry, discovery was filed on and shared on July 28th. And Ms. Reiser's recommendation appears to be 12 months to serve.
That's for one case, but of course, we have the 2 additional cases.
I'm going to reset this case for September 8th. All 3 cases.
Okay.
Well, would it be futile to reset it considering the offer is 12 months to serve?
The thing is, I need the discovery in the other 2 cases and to be able to speak with Mr. Folks about everything as a package.
All 3 cases, Ms. Redden, do you have the 2 other case numbers?
I do.
Okay. All 3 cases are reset to the status calendar, and that's at 9 a.m. Mr. Foltz, you have 3 open cases. Your attorney is Mr. Frank Baker, and all 3 cases are going to be reset to September 8th to see what resolution can be reached by then. Otherwise, the cases are going to be, all 3 are going to be scheduled for trial. All right. Thank you for being here. I'll come up and speak to Mr. Baker. All right. The next one is Jalen Gill.
Yes, Your Honor, that's my case. And we did submit diversion paperwork and did get confirmation from the diversion program that that's been sent. We just need a later date for Mr. Gill. Specifically with him, we would be requesting a January compliance date. Due to his transportation issues, completing the community service is going to be a little bit challenging.
Is he on Zoom?
Judge, I don't see him on Zoom. Is he in the courtroom?
Is there a Mr. Gill here?
Judge, I've had plenty of contact with him. I'll reach out to him now.
Ms. Riley, has he been accepted into diversion?
Yes, Your Honor.
All right. I can reset it to the September 20th at 9 a.m. calendar. He needs to appear in person.
Judge, he will be going to college out of state, and he does live out of state. Is there any way that he could appear virtually?
He must appear in person via Zoom.
By Zoom. Thank you, Judge.
And if he doesn't appear, I don't care what he's done for compliance. I'm going to issue a bench warrant.
I understand. Thank you, Judge.
Thank you. Be advised. All right, this case is reset to 9:20 at 9 a.m. For compliance. Jimmy Gibbons, Ms. Helen?
Your Honor, that's going to be my case. We're going to request a jury trial for this case for Mr. Gibbons. We've received everything, all the discovery.
All right, Mr. Gibbons is present. We're going to generate a case management order, and this is going to be further notice for a jury trial. All right, thank you.
Thank you, Judge.
Tamarcus Irby?
Actually, Judge Katie Elbert, Mr. Irby, do you need me to go to the?
Yeah, it's Mr. Irby.
I'll tell you in a second, but I guess.
Okay. All right.
She's a legend in our office.
Mr. Irby is in Bahrain. He was deployed. He's in Bahrain. He was deployed with the U.S. Navy. That was our announcement the last time we were here on Zoom.
Okay.
He was deployed on October 22nd of last year, and it's a 365-day deployment. So I'm not really sure why. I think they wanted me to talk about a plea in absentia. I have received the discovery. I received an offer to the statutory minimums for DUI. Total candor, I'm not gonna extend myself to do a plain absentia for that. So
Further notice to September 20th.
he's not gonna be back.
Okay, no, I meant for a plea in absentia. If-
No, I'm not doing a plain abstention on DUI minimums. If we can work out a reduction, I'll knock that out. But otherwise, I'd like to wait for him to get back if we have to do that.
I don't have a date right now. When did you say it was October? We have to reset him to any time after October.
He had to report on, I had his deployment papers and he had to report on October 28th. And it was a 365 day
So
deployment.
right now, my reset date's all the way through September 20th, so I need to give you a October date. If you like, we can either wait for it or we can send it to you.
Whatever's easier for the court. If you want to send it to me and maybe that's good. And I promise I won't make you regret giving me a person to get in contact with in Fulton because I'm gonna stalk you. I'll wait and get your card.
All right, further notice to after October 2023. Thank you, Ms. Elwood. Captain John Francois. Mr. Francois is present, represented by Mr. Gator.
Oh, I'm sorry.
We have position number 12, your client.
Yes,
Captain
he's position,
Francois is behind us.
yeah, he's position 12 and 13. I will announce pre-trial with the state in these cases, Judge.
All right. Mr. Francois, please have a seat. Your attorney is going to be speaking to prosecutor. Jermaine Kelly. Attorney, Mr. Kelly is present. Your attorney is Michael Bernard. Where is he?
He said he was
On the way. All right, so let us know as soon as he appears. Gregory Lamar.
Good afternoon, Judge Law, Attorney Sterling Stephenson here on behalf of Mr. Lamar. He is present, he is in the courtroom.
Okay.
Judge, we have received discovery in this matter. I have reviewed it. I also have an offer from the state, which was communicated to my client. We are going to decline the state's offer. We'd like to set it up for a bench trial. And also between now and whatever the bench trial date is, I will be reaching out to the solicitor to pre-try the case again, because I don't believe they've actually looked at the video and everything that's in discovery. But for the purposes of today, we would like to announce we're declining the offer. We'd like to move forward with the bench trial.
Well, let's see.
Your Honor, good morning, good afternoon, counsel. Judge, I do show that discovery was served both on October the 5th of 2022 and then subsequently on July the 10th of this year. The video and 911 also were shared on July the 28th of this year. The offer, if the defendant were to plead guilty, would be 12 months probation, complete the family violence intervention program, and no further contact with the victim. Regarding the request for the bench trial, Your Honor, the state would oppose and would request a jury trial in this matter. The offense is battery family violence.
Anything else to add, Mr. Stephenson?
Oh, a bench trial would suffice in our view, Your Honor. That's the only,
Yep.
that's our stance.
Well, the client has the right to waive the jury trial and request a bench trial unless the state opposes it.
Okay.
Then we set it down for a jury trial. I'm going to generate a case management order and further notice a case for a jury trial. You will receive notice of your calendar call for a jury trial.
Okay.
I do not know when it's going to be.
Okay.
But it'll be down the road. Okay?
Understood, Your Honor. And that concludes my business with the court. May I be excused?
Yes, thank you.
Your Honor.
And Your Honor, if I could just let counsel know, Jordan Reiser will be the Assistant Solicitor General on this case, so you're welcome to reach out to her if you want to further discuss the case.
Thank you very much, and I definitely will.
All right, thank you.
Thank you.
Alexis Miller, Ms. Helen.
Judge, that'll be my case. We'll announce pretrial. I just want to get the offer from the state.
All right, Ms. Miller, please have a seat. Your attorney will be discussing your case with the prosecutor.
And Judge, I'll just let Ms. Helen know, it's the offer that was that I indicate was communicated is DUI, statutory minimum sentencing conditions would be the offer.
All
The
right.
video was shared and the discovery according to my notes from Ms. Reiser.
If we could just have the
You
minimum.
can still have a moment to.
Sure. Sure, thank you, Judge.
Okay. Jamila Ponder, Mr., is that going to be?
No, Judge, I've entered in a substitution for Ms. Ponder. I'd also like to announce a pretrial for that case as well.
Is Ms. Ponder, the
Yes.
lady back there?
Yes.
Okay, all right.
It's my understanding, Ms. Helen, that was supposed to be a plea, that the plea paperwork was submitted.
That's correct. I do have the DocuSign. I just want to make sure that I have that correct, and I'll be submitting that today, Judge.
All right, so this will be a plea today?
That's correct, Judge. We also just have a couple other questions because it is a DUI. There's a hardship waiver that I had questioned ASG Rising concerning. She wasn't aware of that, so I'll just present that question to the court
All right.
for Ms. Ponder.
Bring it up when I address the plea.
Understood, Judge.
Position 18 was addressed, position 19 was addressed, position 20, Diana Reed. Diana Reed.
Yes, Judge. Attorney David Rigdon here, filling in for Scott Fortis. She's here, and that's going to be a plea.
All right, I got the documents, so we will proceed with that shortly. Thank you.
And Your Honor, you also, the court should have, Ms. Reiser filed an amended accusation for disorderly conduct. The court should have that as well. Is that your understanding? It's a plea to disorderly conduct, counsel?
Yes.
I'm just making sure.
And I think Odyssey shows she filed it, I believe, on July 31st.
So amended, yes.
Yes.
Thank
Mhm.
Antoine Sterling.
Good afternoon, Judge. That's Mr. Sterling. He is positions 21 as well as 22. Specifically, give me 1 second, Mr. Sterling. We're missing the discovery for both cases, but specifically for 4120, which is position 22, we're missing the police report, the warrant, and the body worn camera, Judge, but I have entered in my appearance, and so we're just still waiting on that. So we did ask for just a reset just to get that discovery, Judge.
Ms. Helen, Ms. Reiser's notes to me indicate she sent it on the 28th of this year, of this month, of last month, rather. You did not receive it? That was regarding position 22?
That's correct for Mr. Antoine Sterling.
Right.
No body worn camera, no police report, no warrant. And it's also hasn't been posted in Odyssey either.
I don't see that on Odyssey, Ms. McCutcheon. Maybe we can follow up on that. For positions 21 and 22, they are reset for a final plea calendar.
All right, thank you. And I'll make certain, Ms. Helen, that I send an email to Ms. Reiser letting her know of the issues with those two
All right.
cases. And the
This is
discovery.
reset to September 8th at 1:30 p.m. And if the plea hearing is still moving forward, then please make sure those documents are ready by the time we address that.
Yes, Judge.
All right, moving on to position 23, Derek Walker. Mr. Gaper.
Good afternoon, Judge. I'll announce pre-trial in that case. Mr. Walker's present.
All right, 23 is a pre-trial. 24 is Michael Watson.
Yes, I'm here.
Hey, Your Honor, this is Attorney Keith Fallon from Mr. Walker. This is going to be a plea. The paperwork should have been submitted and received already.
Ms. McCutcheon, do you have the paperwork for?
I'm sorry, Judge. What position was that? That's Mr. Walker?
24.
It says that the plea papers were submitted already. Yes.
Okay. Ms. Redden is going to try to retrieve them. In the meantime, if you all have a copy, please redirect them to monica.redden@fultoncountyga.gov.
And I apologize to the court, Your Honor. I am not, I don't have DocuSign capability. So if counsel has a copy that you can forward to myself,
yeah,
and I will forward, I don't have the capability, I don't have an account with DocuSign.
But I would do it. If you could put your email in the chat box and make sure I got the correct, I'll do so.
Okay, there's Mr. Farmer. Okay, I was looking for you. I will do that. I'll put it in the chat.
Oh, Ms. Redden, you can also send Mr. Farmer your email.
Oh, okay, that'll be fine. Do you want me to send it, Ms. Redden, or are you going to do it?
No, let's just get it from one point A to point B without going through, you know.
Yes, yes, Judge, I'll do it. Mhm.
Mr. Farmer, you'll see an email for you to send. Position 25, Deshaun Williams.
Yes, Your Honor. That case is Mr. Haddad's case. Is Mr. Williams present in the courtroom?
Yes, he is.
Okay, Judge. The announcement on behalf of Mr. Haddad is going to be that they would like to move forward with a jury trial.
All right. Mr. Williams, we're going to issue a case management order. The case is going to be further notice for a jury trial. You will receive notice of when to come back to court, and your attorney is Mr. Dwayne Haddad with the Public Defender's Office. All right, you're free to go. Thank you. Deanna Wimbley.
Judge, that's going to be my case. I believe Ms. Wimbley is here. We're just going to announce a pretrial, Judge. I do believe we'll have a resolution. I just need the offer for that case.
Ms. McCutcheon, give the offer.
Yes, Judge, I was emailing my address to Mr. Farmer. What position is that? And I'll give the offer.
Position 26.
Okay, position 26, the offer that was emailed according to Ms. Reiser's notes for offer of 12 months probation, 12 anger management classes, no further contacts with the victim, and to stay away from the incident location on a plea of guilty to simple battery.
Okay, so that was 12 months probation with 12 anger management classes, no contact and stay away.
Yes, Your Honor.
Understood, Judge. Just give us an opportunity to pre-try that.
All right. Okay, is there anyone who has a client or is the defendant whose name I did not call? And I'm directing that to everyone who's on Zoom. I didn't call your name or didn't call your client's name. Please unmute and let me know now. Okay. Is there any defendant or attorney whose name I called or did not call? And yes, sir.
Afternoon. My name is Michael Bernard. I'm here for Mr. Kelly, Jermaine Kelly.
All right, Kelly, right?
Yes.
Give me a moment. Yes, sir. And how would you like to proceed today, Mr. Madad?
Judge, we could just ask that this case be further notice to a trial calendar.
Jury or bench?
Jury.
All right, so with regards to position 14, State versus Jermaine Kelly, accused of one count of battery, not DV. The case is going to be further notice for a jury trial. And we will generate a case management order today.
Okay.
All right, that's it. Thank you. You're free to go. Okay, before I start with my plea, and if anyone else whose name was not called, okay, before I begin with my plea hearings, Ms. Rosenhuber, and okay, you have Mr. What was it? Mr. Batson, was it?
So yes, I have not been able to reach Mr. Batson yet. I'm still hopeful he'll come before court is over. I know that he was having technical issues earlier. With respect to position 6 on the status counter from this morning, Mr. Griffin, we're ready to proceed. And with respect to number 7, Mr. Hamer Hodges, I'm still speaking with him, Judge. I'll have an updated announcement shortly on him.
All right, okay. Please hold tight. I'm going to address the cases in the courtroom first, and then I'll address the cases on Zoom. Okay?
No worries.
With the exception, Mr. Rigdon, your client's on Zoom as well, right?
Yes, Your Honor.
Ms. Brock, who was your client?
Wilson Andrews.
Okay, let's get started, please. And if you'd like to come up to the podium with Mr. Andrews next to you. And Ms. Riley, that's you? For position 2 on the calendar?
Yes, Your Honor.
This is State versus Milton E. Andrews Jr., case number 21 CR 0055558F. Mr. Andrews was originally accused of reckless driving and failure to maintain lane or improper lane change from November 1st, 2019. Mr. Andrews, you've been advised of your right to remain silent. Your attorney is Ms. Brock, and we're going to proceed with the plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Wiley, what's the plea offer?
The terms of the plea, Your Honors, to the count of reckless driving, 12 months to serve 24 hours, credit for time served, 24 hours, the balance on probation, a $800 fine, a risk reduction course, 1 victim impact panel to be randomly screened while on probation. Count 2, the failure to maintain lane will be null prost.
Ms. Brock, are those the terms to which your client is agreed?
Yes, Your Honor.
And do you stipulate to the factual basis that you and I?
Yes, we do.
Thank you. Mr. Andrews, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney's services?
Yes.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained to you that if you decide to plead guilty to reckless driving, that you'll be giving up your right to go back to court and have a trial in front of a judge or a jury to confront your accuser, have the assistance of counsel to challenge the state's evidence, examine witnesses, and have the state try to prove the original charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of reckless driving?
Guilty. Guilty.
Your sentence is 12 months to serve 1 day, credit for time served 1 day, balance probated. You'll report to probation next Thursday before 3 p.m. at 132 Mitchell Street. Before you leave, you'll be filling out form for probation. While on probation, you'll pay a $800 fine, complete a risk reduction program, attend 1 victim impact panel, and also be subject to random screens for illegal drugs and alcohol. The charge of failure to maintain lane is going to be null prost, so the only conviction that appears in your record will be for reckless driving. Yes, Ms. Brock, was there concern about reporting?
Correct, Your Honor. He actually lives out of state.
Where?
South Carolina.
South Carolina, okay. I will allow for telephonic reporting to probation. You'll be paying probation fees to Fulton County every month. And unless you'd like to work with probation to see if they can transfer your probation case, that's a question of finding, making sure that we sync it up with the probation office in the county or in the borough or in the district where you live.
Okay.
All right. So this will be telephonic reporting. Of course, if they call you for a random screen, you would have to go to a qualified screener in the area where you live. And that screener would have to be in touch with your Fulton County probation office. All right, the probation form is filled out. We can make a copy, the probation address and phone number.
Thank you, Your Honor.
All right, thank you. I'm only going right now with the piece where I have the documents. We're still waiting to get the documents for the other cases. I'm going to next address Miss Diana Reed, position 20. Diana Reed.
Yes, thank you, Judge.
That's Mr. Okay. Okay, this is position 20, case number 20, COV 0000220, State versus Diana Reed, accused of disorderly conduct on June 8, 2020. Ms. Reed, please unmute. And video, start your video. Okay. Ms. Reed, please raise your right hand. Do you solemnly swear and affirm the testimony you provide for purposes of this plea is the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You've been advised of your right to remain silent, and your attorney is going to be Mr. David Rigdon with the Office of Scott Fortis. All right, Ms. Riley, what is the, sorry, Ms. McCutcheon, what's the plea offer for Ms. Reed?
Yes, the plea offer for Ms. Reed is that the state is reducing and amending the terroristic threats charge to disorderly conduct. The recommendation is a 12 months on probation, a $300 fine, 40 hours of community service, 12 anger management classes, to stay away from the incident location, which is at 762 Celeste, Celeste Way in Atlanta, Fulton County, Georgia, and to have no contact whatsoever with the victim in this case, whose name is Janina, first name Janina, last name Milligan, common spelling Milligan. And had this case gone to trial, Your Honor, the state would have expected the evidence to have shown that on the date of June 8th, 2020, Atlanta police officers responded to the 762 Celeste Lane Southwest, the incident location, made contact with the victim, Ms. Janina Milligan, who indicated that residents at that neighborhood community had come to her home, banging on the door, ringing her doorbell, calling her a bitch, telling her to come outside, threatening that they would kill her. A neighbor identified as a Miss Booker also spoke with the officer who responded, indicated that she actually saw the commotion as well, that she also heard and saw the female identified as this defendant, Dayana Reed, at the victim, Miss Milligan's address that morning, yelling about her car having been towed from the community and threatening to beat and kick Miss Milligan's ass. The officer then detained the defendant and she was arrested based on the conduct, violent and tumultuous conduct that she had exhibited towards Miss Milligan and the other witness. And that, will you stipulate then to the factual basis, counsel, for the plea to guilty of disorderly conduct?
Yes.
All right, thank you, Ms. McCutcheon. Ms. Reed, are those the terms to which you've agreed?
Yes.
And Mr. Brickton also stipulated to venue and ID, correct?
Correct.
Ms. Reed, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney's services?
Yes.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
Has it been explained to you that if you decide to plead guilty to disorderly conduct, that this will close the case out and you'll be placed on probation? You will not have the opportunity to go back to court to have a trial in front of a judge or a jury. You will also have to give up your right to confront your accuser, examine witnesses, challenge the evidence brought by the state, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
One count of disorderly conduct.
Yes.
How do you plead?
Guilty.
The sentence is 12 months to be served on probation. You'll report to probation next Thursday. You might want to write this down. Next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. Once you report to probation, you'll be placed on probation where you report once a month. You would need to pay a $300 fine, complete 40 hours of voluntary community service at any nonprofit agency, which is not a school and not a church. While you're on probation, you also complete 12 anger management classes. At all times, you have to have no contact with Janina Mulligan and stay away from 762 Celeste Lane in Atlanta, Georgia. Mr. Rigdon, anything else to add?
Judge, I don't know if you said, does the probation end terminate upon completion over conditions, or is it the full 12 months?
Judge.
12 months.
Okay.
Yes, Judge. Thank you, Your Honor. That was going to be the state's request.
Anything else? No? Okay. Please don't forget to have your client report to probation next Thursday before 3 p.m. All right?
All right. Thank you, Judge.
Thank you. All right, you are free to go. Thank you. Okay, next position I have is Brandon Griffin. Brandon Griffin.
I'm ready on that, Judge.
Mr. Griffin, are you driving or being driven?
I'm not driving.
Pull over and make sure your phone is in front of you. All right, when you're pulled over, then we will be ready to proceed with your case.
Yes, ma'am.
Michael Wharton and Mr. Farmer.
Your Honor, for some reason, it did not come through the email. However, Mr. Farmer just sent it to me through the chat, and I am downloading it now from the chat so that I can look at it, Judge.
No, I've got the plea documents. So I'm ready to proceed. Are you ready?
Yes,
Yeah.
Judge, I just haven't seen them. I thought the court wanted me to look at them. I'm aware of what Ms. Reiser has indicated to me in her notes as to what the plea recommendation is. So the state's ready in that regard.
I've got
back to that,
12
Judge.
months probation, 40 hours community service, no further violent contact, and complete DVIP. Was there anything else?
No, Judge, I believe that's it. And Judge, just tell me again the case number, the number, position number of that case.
Position 24, 21 CR, 4334F.
Right. Yes, and the victim was a Davika, D-A-V-I-C-K-A, last name Wharton. If I can just sound, Your Honor, to ask if there is a Ms. Davika Wharton on the Zoom for the plea. Does not appear to be. Okay.
Okay. All right, so I'm going to proceed. This is State Mrs. Michael Wharton, 21 CR 4334F, in which he was formerly originally accused of battery, domestic violence, from August 6, 2021 in Fulton County, Georgia. Mr. Wharton, you've been advised of your right to remain silent, and your attorney is Mr. Keith Palmer. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
And Ms. McCutcheon, are you ready to proceed?
Yes, Judge, I was having a little bit of difficulty pulling the case up, but I see now. Had this case proceeded to trial, the state would have expected the evidence to show that on the date of August the 6th of 2021, officers responded to the location. Well, actually, Ms. Davika Wharton came to the South Fulton precinct, the South Fulton Police Department located in Fulton County. And she spoke to one of the officers there in reference to a domestic dispute. She advised that she had been in a physical altercation with her husband, Mr. Michael Wharton, previously on August the 5th of 2021, that he had been drinking that night. She was sitting at the kitchen table when he threw a bag at her. He then snatched her necklace from her neck, causing it to break, and then took her cell phone. He came behind her as she retreated to the bedroom, yelling at her to take her shit out of the house and get out. As she was getting her belongings from the bathroom, he punched her in the lip, causing swelling, then pushed her down to the floor, causing her to hit her face on the ground, threatening that he would kill her as he went into the room where he kept his gun. She ran out of the house to neighbors so that she could use the phone. He came out looking for her. I'm just reading the report to see there's no indication that he brandished a gun, but he then took the garage door opener and the house keys from Miss Wharton so that she was not able to leave. She was able to call her son. And then after the defendant left, she went back into her residence. Judge, and I must say, I'm covering the case for a colleague, but I'm very concerned about the fact that there is an allegation about a firearm having been used. I just wanted to look to see how the accusation is actually charged. So he's charged with punching her in the mouth, causing swelling and pushing her. Judge, is it possible for us just to hold off for at least 5 minutes so that we can try to contact this victim, Ms. Wharton, to see if we can get her on the Zoom? If is there a victim advocate? Is Ms. Clemens or another victim advocate, Ms. Riley, on the Zoom?
I'm here, Ms. McCutcheon.
Ms. Jackson, have you spoken with Ms. Wharton?
I have not. We were unable to make contact, but I'll reach out to her and see if I can get her.
Judge, if we could have 5 minutes, I'm very concerned about the narrative in the police report.
All right, we will.
Thank you.
Pause for 5 minutes, and then Mr. Griffin, have you pulled over?
He chatted me and said he is ready, Judge.
Brandon Griffin?
Mr. Griffin, are you there?
All right. I'm still waiting on the plea paperwork on the other cases. Matson, Hamer, Hodges, Alvarado, Bagley, Ponder. I'm still waiting on the plea paperwork for these cases. before I can proceed.
Judge, while we're waiting on Mr. Griffin to turn his camera and audio on, okay, there he is.
All right.
Okay, excellent, thank you. Okay, this is Mr. Griffin
Yes,
from
ma'am.
position 6 from the 9 a.m. calendar. This is State versus Brandon Rashad Griffin, 21CR 003-478F. Mr. Griffin was accused, where has he gone to now? My God. Okay. Mr. Griffin, we need your face on the video and your season not moving, and I don't want to see the sky. I don't want to see the trees. I can see that on myself. I don't need you to show that to me. Do you understand?
Yes, ma'am.
Thank you. Again, this is State versus Brandon Griffin, accused of battery, domestic violence from May 3rd, 2019. Mr. Griffin, you have a right to remain silent about the facts of the case. Any comments you make, your statements can and will be used against you. You have a right to an attorney, and Ms. Sarah Rosenhuber with Public Defender's Office will be representing you. For purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, great, thank you. All right, Ms. Riley, what is the plea offer for Mr. Brandon Griffin?
Yes, Your Honor, it is 12 months to serve 2 days, credit for time served, 2 days, the balance on probation, a family violence intervention program, and to have no further contact with the victim, Nicole Satterfield.
All right. And Ms. Rosenhuber, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do, and we ask that the court accept the negotiated resolution.
All right, thank you. Mr. Griffin, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained that if you decide to enter a guilty plea to this charge, which is battery, domestic violence, that any future arrest for the same offense will automatically be a felony charge?
Yes, ma'am.
Right? And you also understand that if you enter such a plea, that you'll be giving up, and it's giving me the scenic view. All right. Do you understand that if you enter this plea, that you will be giving up your constitutional right to a jury trial or a bench trial, that you will not be able to go back in court to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, domestic violence?
Yes, ma'am.
How do you plead to one count of battery, domestic violence?
I plead guilty.
Right? Your sentence is going to be 12 months to serve 2 days, credit for time served 2 days. For the remainder of the time, you'll be on probation. You will report to the probation office at 132 Mitchell Street in downtown Atlanta. The information is also on the chat feature of the Zoom. You'll report next Thursday before 3 p.m., at which time you will then be placed on probation, and you'll report to probation every month. While on probation, you will complete a 24-week domestic violence program. You must enroll in those classes within 60 days from today, and you must complete all 24 weeks of classes at your expense. You're also to have no contact with Nicole Satterfield. You have to stay 200 yards away from her and not communicate with her in any way, form, or manner. Do you understand, Mr. Griffin?
Yes, ma'am.
All right, Ms. Rosenhuber, please make sure that your client reports to probation next Thursday before 3 p.m. Okay?
Yes, Judge. And just because I haven't handled a plea over Zoom yet, do I need that probation form to give to the litigation managers.
She, Ms. Redden just emailed it to you to fill out.
Great.
But just make sure your client knows he has to report in person.
I will do so, Judge. Thank you.
All right. Okay. Any questions, Mr. Griffin?
No, ma'am.
All right. That concludes your case. Thank you.
Thank you.
And Your Honor, I apologize. Which positions from 1 through 13 are you waiting on plea paperwork for?
Okay. I'm waiting on paperwork for position 1, Alvarado, position 3, Bagley, and then position 17, Ponder.
Okay.
And then on Ms. Rosenhoover cases, I'm waiting on Batson and Hamer Hodges. Paperwork.
Yes, Judge. So for Mr. Batson, I did speak with him again. He is having difficulty getting onto the Zoom feature. I've advised him that he needs to either show up in person or find another device. Otherwise, he will have a bench warrant. And he's still continuing to try to get on, but that's my update on him. I don't anticipate a plea today, just so the court is aware.
All right. Well, we're going to wait till the end of the calendar, then we'll find out. Okay. All right. Ms. McCutcheon, are you ready to resume with Michael Wharton's case?
Your Honor, I believe she may be speaking with the victim.
Yes, Judge, I've not had any contact with the victim myself. I'm waiting for, I'm looking at the notes from Ms. Astrid. She reached out, the victim did not call back. Judge, and I'll just state in my place, I'm not comfortable as a prosecutor taking this plea when there's an allegation that someone threatened to kill someone and went into a room where there was a gun. Until I personally can speak with the victim or have someone in my office speak with her to verify those facts, I'm not comfortable going forward. I did not make the recommendation. And after reading the facts, I'm not comfortable with that plea today.
Your Honor, if I may, I've gone through this with other ASGs, and we got to the point to where we addressed what the issues or concerns were with previous attorneys assigned to the case. We got plea worked out, and it would have been final last session, but for the DocuSign program that they want to potentially use my client. So we're ready to move forward, Your Honor. I don't know what further we need to be said or addressed that we haven't already done so previously.
Just let me see one thing. I want to. All right, the bond order required him to have no further contact with Dabika Horton. That seems to be perhaps the stickler point about whether there shall be contact with Dabika Horton. Sorry, Dabika Wharton, which I'm assuming is his spouse.
That's the state's indication, Judge, from the facts and the notes in our file that they were married. I would ask, Judge, respectfully, I ask that the case be reset so that we can get the victim to appear and present and be present. Ms. Riley, I'll refer to Ms. Riley. I just, as a prosecutor, do not feel comfortable tendering the plea, Judge. Not when I'm reading a report and there's an allegation such as this. Of course, I know the defendant is presumed to be innocent, but when there's an allegation such as this and a recommendation of straight probation, I, as a prosecutor, do not feel comfortable because I have not personally spoken with the victim. And I would think the victim would need to be present to indicate to the prosecutor and to the court whether or not she is satisfied with this plea recommendation.
Ms. Jackson, no word yet from the Ms. Wharton?
No, ma'am, I still haven't heard back. I'm actually gonna send her an email also.
All right, and Mr. Palmer, is your client still married to this lady?
Yeah, yes, Your Honor, we have been. And she has reached out to my office several times regarding not want to participate in the case. I've given her the victim's advocate number. I've given her the prosecutor's office number. She's indicated last I've known that she contacted and had contact with them about where her intentions have been. That is what has led us want to do this plea and trying to get it over with as well, Your Honor. So I
Can
don't,
you reach out to her with a Zoom link and let her know that she's holding up this plea hearing if she doesn't appear?
you asking me, Your Honor, to reach out to her?
Yeah, she reached out to you, right?
She has reached out. It's been several months since I last heard from her, but she has had contact with my office, Your Honor.
All right, if you have resources to find a current contact or email or phone number, she's holding up the plea hearing for her spouse. The amendment is no further violent contact with the vehicle court. She just needs to show up. Prosecutor wants to speak to her before they want to proceed.
I will attempt to reach out to her, Your Honor.
All right, appreciate it. Thank you. All right, for the rest of you who are waiting, your attorneys are speaking with the prosecutors.
So the 9 o'clock calendar, we announced which one, but he's now present.
All right, Mr. McHenry? McHenry? McHenry, yes, Shackerton, McHenry.
Judge, Mr. Batson has joined the Zoom.
All right, excellent, thank you. Mr. Rosenhofer, do you need to speak to your client to get the paperwork squared away?
I apologize, Judge. I'm on the phone with Mr. Hamer Hodges. Would you repeat that? I heard my name.
Mr. Demetrius Batson is joining the Zoom. As soon as he's connected up, he doesn't have audio. All right.
Okay.
Mr. Batson? Here we go again. Mr. Demetrius Batson, this is Judge Lal. I need you to start your video and your audio. All right.
I'll continue to try, Judge. I'm trying to figure out what Mr. Hamer Hodges wants to do at the same time, but I'll report back. Thank you for your patience.
I'm here. You guys have not got nowhere to go. All right. Let's see now, Mr. McHenry. This is Shackerton?
Yes, Judge.
Oh, I'm sorry, from the 9 a.m.
From the 9 a.m. calendar. We actually had the bench warrant ready for you to sign.
What's this on the?
The 9 o'clock status.
Status.
Yes. No worries. It's the Mac, Your Honor.
Oh, yeah, I understand.
Your Honor, I don't know if you're looking at something else right now, but I do have an announcement on Mr. Hamer Hodges.
Okay.
We are very, very close to working out a plea agreement. However, because the terms shifted and it was a great offer for today, he is asking for a little bit more time just to look over everything and consider the impact that a conviction would have over the course of his life. He's not wanting to reject the offer, but he does understand that the state has the authority to pull the offer. And it's his decision to ask the court for a reset date.
Denied. All right, so he can confer with you a little longer, and then if he's ready, we can proceed.
Okay, Judge, thank you.
All right, Mr. McHenry, your case was scheduled for 9 a.m. We were in court until 11, I think it was 11:20.
A little bit later than that.
Yeah, and you did not show up. And so I have a bench warrant for your arrest for failure to appear. Your attorney, I don't know who your attorney is. I'm going to amend this to a $500 signature bond through the jail. I want you after today to go report to the Fulton County Jail. Be booked in, close out the warrant, and then you can be released on a signature bond through the jail.
Okay.
This is for failure to appear in court on time. This is not your first time. Put your arms down so you're addressing the court.
Yes, ma'am.
Put your arms down. You are addressing the court.
You say this is not my first time?
That's correct.
I don't remember my last time. I don't.
Your last time was before Judge Richardson on April 19th, 2018. And then where you did not appear for your trial date and your bond was forfeited. In fact, you already have a bench warrant. I don't even need to issue this one. You already have the bench warrant.
That's what I'm looking now.
It's the bond forfeiture. Unless Judge Richardson did not sign. Oh, no, the bond forfeiture was set aside on May 2nd, 2023.
Okay, ma'am. So you say I report to the Fulton County Jail and hand them that letter?
No, we will send them the warrant.
Okay.
All right. And the bond's going to be amended to a $500 signature bond through the jail.
Yes, ma'am.
And then your next court date is going to be set for Mr. Wharton, please mute your screen unless you want us to hear your conversation. Do you understand, sir?
Yes, ma'am.
This is going to be a failure to appear that shows up on your record. And then your next court date is going to be September 8th. And that's going to be at 1:30 p.m. in this very courtroom.
Yes, ma'am.
All right, now you know where we are. You understand?
Yes, ma'am.
Okay. You are free to leave and you make sure you get to Fulton County Jail as soon as possible to close out this warrant. And then we will see you on September 8th at 1:30 p.m.
Yes, ma'am.
This will be your second failure to appear in this case. Don't make a habit of it.
Yes, ma'am.
Thank you. Do you want to amend this or would you accept this?
I think I need to read it out just so there's not any issues. I don't want them to
Okay. Mr. Palmer, any luck with Mrs. Wharton?
Yes, ma'am. I was able to get in touch with her via text. I told her the victim's advocate in the court is trying to contact her. She said that she was stepping out of her meeting now and giving them a call. So
Appreciate it. Thank you so much.
yes, ma'am.
I'm just inquiring of the defendants in the courtroom and letting them know that that council will report the announcement shortly.
Yes, I am still trying to get in contact with Mr. Cherry. Mr. Cherry, if you're in the courtroom, could you please give me a call? The two numbers that I have for you, I can't get through to you.
I didn't bring my phone.
Okay. Are any of the PDs in that courtroom right now, or are all of them
Mr.
stepped out?
Gaither had stepped out, but
Okay.
does he have your phone number?
He does have my phone number,
Okay.
Judge.
As soon as he appears, we'll have him use Mr. Gaither's phone.
Thank you. I appreciate that.
Obviously, arm and a leg, but we'll allow it.
Your Honor, you have quite a few individuals in the hallway waiting to speak with Mr. Gaither.
Okay. Everyone has to take their turn.
Right.
Okay. Ms. Rosenhuber, are you still in conference with Mr. Hamer Rogers?
I am still conferencing with him, Judge. And as for Mr. Batson, he has been messaging me and he's saying that the audio is not working. It's not even showing a speaker, just a camera. Is there any way that I can dial in?
I read the chat. I read the chat.
Okay.
Please instruct him that he needs to appear in court in person. This has been going on since 9 a.m. And you've already explained the consequences to him. So
Yes, Judge. And he does live out of state. And so he would not be able to make it in person.
well, this is news to me.
Yes, Judge. I'm sorry I didn't say that at the 9 a.m. conference, but he is not in the state of Georgia.
Well, where is he?
His address, Judge. Sorry, I have quite a few files that I am.
No, that's okay. I'm not giving him a dial-in option. He's been doing this since 9 a.m. Now it's turned out to be ridiculous and dilatory. So
I understand, Judge.
he needs to be in court.
Okay.
His hand up. Thank you, Mr. Batson. We can't hear you. If you'd like to address the court, go ahead. All right. I can't hear him. I can't see him. So
I understand. I'll continue to try to get him here. And Judge, I did just speak with Mr. Hamer Hodges. As soon as Miss Riley has a minute, I don't know if she's speaking with another attorney right now, but we'll be ready on that plea.
And do you have the paperwork for Mr. Hodges?
I do. I can forward that to Miss Redden, right? Okay, I'll send that right now.
Appreciate it. Thank you.
Judge Law, can I get a breakout room with ASG McCutcheon? This is the victim advocate.
All right, I see that. Ms. McCutcheon?
Yes, Judge. I'm sorry, I didn't hear that, Judge. I was talking with Ms. Reiser, Your Honor. I apologize. What was the court saying?
Are you open to a breakout with the victim advocate?
With Ms. Jackson, I am, Judge, yes.
Mr. Glanville?
Okay, I see it. I'll join. Thank you.
Ms. Rosenberg, we're just waiting on the plea paperwork. As soon as we get that going, we will begin with Mr. Hamer Hodges.
Great, Judge. Thank you. And I'm guessing that Mr. Gaither's pretty swamped. So, Mr. Cherry, I'll speak with you as soon as I can, but check your email. I did send you an email a while back.
He doesn't have
any phone. That's right. I'm sorry. It's been a long day, Judge. You know. Apologies.
Then, yes, I did just get off the phone with Mr. Gaither, so he is working.
I know.
And so are we doing Mr. Hamer Hodges?
Yes, as soon as I get the paperwork, I will announce we're ready to proceed.
She just said that thing, it just went somewhere.
Ladies and gentlemen, if you need to hold a conversation, please step outside the courtroom. Thank you. Ma'am, if you need to hold a conversation, please step outside the courtroom. Thank you.
Ms. Rosenhoover, never mind, I have it. Thank you.
Great, no problem. I just resent it.
You didn't sign, you only signed it. Mr. Alvarado, you have to complete every last page for a total of 4 pages. You only completed the first page.
Mr. Alvarado, did you read all the pages?
I thought it was just the first.
No, it's like being in a doctor's office. You have to look at all the pages, okay? Not just the top page. All right, let's proceed with position 7 from the 9 a.m. calendar. With regards to Mr. Hamer Hodges. Mr. Hamer Hodges, please start your video. And if the host could please remove the yellow hand signal from Mr. Batson, please, thank you. All right. This is position 7 from our 9 a.m. calendar, Orca status matter, 21 CR 4271F is the accusation number. State versus Christopher Hamer Hodges, hyphenated. Mr. Hamer Hodges was accused of battery, family violence from August 14th, 2021. Mr. Hodges has been advised of his right to remain silent, and his attorney is Ms. Sarah Rosenbluth. Mr. Hodges, for purposes of the plea, may I place you under oath?
Yes, Your Honor.
And affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, Your Honor.
All right, Ms. Riley, what's the state's offer for Mr. Hamer Hodges?
Yes, Your Honor. It is to a plea to count 2, which is battery. However, that was just added today. I'm not sure if it's been accepted by the clerk's office yet. It's 12 months on probation, 12 anger management classes, an alcohol and drug evaluation, and any treatment that is recommended, and to have no further violent or harassing contact with Mr. Peter Hamer Hodges, who is Mr. Christopher Hamer Hodges' father.
All right. So basically, you are adding a separate charge of battery and going to null cross the battery family violence. Is that correct?
Correct. Yes, correct, Your Honor.
Please submit the null cross to Ms. Redden as soon as you can.
I will.
Ms. Rosenhoover, are those the terms to which your client has agreed to 1 count of battery as opposed to battery family violence?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
I do.
Mr. Hamer Hodges, so it appears that the charge is going to remove the domestic violence element of the offense. So that keeps you out of any possible danger of being arrested for a felony charge should, heaven forbid, such an incident be repeated again. Do you understand? Okay.
I do.
All right, and Mr. Hodges, have you consumed any alcohol or medication recently?
No.
And have you understood the proceedings so far?
Yes,
And are you satisfied with your attorney?
I am.
And has it been explained to you that if you decide to plead guilty to 1 count of battery, that you will be giving up your right to go back to court and have a trial, to confront your accuser, examine and challenge the state's evidence, examine witnesses, whether it's on direct or cross, and also have to have the state try to carry its burden of proof or proving the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead? One count of battery.
Guilty.
Your sentence is 12 months to be served on probation. You'll report to the probation office in Fulton County, Georgia, next Thursday, which is August 11th, before 3 p.m. And that would be at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 12 anger management classes, submit to an alcohol and drug evaluation, and pay for any treatment that's required by the evaluator. The anger management classes must begin within 60 days of being released. The alcohol and drug evaluation must take place within 60 days of being released. You are also to have no violent contact with Peter Hamer Hodges. The charge of battery domestic violence will be null pros. If you complete the anger management classes and the alcohol and drug as well as any treatment, then I will allow your probation to be non-reporting. Any questions, Mr. Hamer Hodges?
No, thank you.
Right, Ms. Rosenhuber?
No, Your Honor, thank you.
All right, don't forget to report next Thursday. And Ms. Rosenhuber, we're going to send you the probation form to be filled out.
Great. Thank you, Judge. And I'll send that back as well as with Mr. Griffin's.
All right, thank you.
By 3 p.m.
Before 3 p.m., yes.
Okay.
Thank you.
Thank you, Your Honor.
Right, you're free to go. All right, Ms. McCutcheon and Mr. Palmer, what are we doing in the Michael Wharton case?
Good morning, good afternoon again, Judge. Your Honor, first of all, I appreciate the court's indulgence and patience, but I always want to do my due diligence. And I have spoken with the victim in this case, Ms. Davika Wharton, and based on my conversations with her and her conversations with Ms. Jackson, the victim advocate today, the state feels confident to go forward, but I wanted to be assured as to what went on during this incident before I tendered the plea on behalf of the state. But I feel comfortable going forward now, Your Honor.
All right, we will resume the plea hearing in 21 CR 004334F, where Mr. Wharton's already been advised of his rights. He's already been sworn in. And I believe we left the juncture where the state was elocuting his plea offer.
Yes, Judge. I think I completed the factual basis. So counsel for the defendant, do you stipulate to a factual basis for the charge of battery family violence in this case?
Yeah, for the purpose of a plea, we do stipulate to this.
Yes, and Judge, this did have, the defendant was identified by the victim, who is his wife, was his wife at the time of this incident in August of 2021, specifically on August 5th, when she alleged the incident occurred and when she spoke with police subsequent to that date. And this is alleged to have occurred. The state would expect the evidence to show it did occur at 7460 TOCCOA, Toccoa Circle, South Fulton, Georgia, Fulton County. The state has recommended on a plea of guilty to the battery family violence that the defendant be sentenced to 12 months probation, that while on probation, he complete the 6 months family violence intervention program counseling, that he complete 40 hours of community service, that he have no further violent contact with the victim, Mrs. Davika Wharton. Ms. Wharton indicated to me that she is still married to the defendant. She and the defendant intend to resume their marital relationship. She wants to have contact with him because they have children and grandchildren together. She indicated to me that although there was a gun that was in the home, that the defendant never brandished the gun, never pulled the gun out. The gun was never displayed, but she was aware there was a gun. And she thought that when the defendant threatened her that he was going into the room to retrieve the gun, but actually what he went in the room to retrieve were her clothing, that he then was retrieving her clothing and yelling at her to get out. She states that she is not in fear of the defendant currently, and so she would like to have no further violent contact with him. And she also indicated that she is satisfied and feels that the state's recommendation to the court for sentencing is appropriate. I would ask, Judge, that the defendant be ordered to remain on probation throughout the entirety of the 12 months. I do not know if that was negotiated with the prior ASG, Mr. Farmer. Was that any issue about that?
No, the understanding was that we will revisit it once he finished all of his conditions, but it was not requested nor granted that probation went in early.
Well, Judge, on behalf of the state with a case dealing with this type factual basis and the nature of the case and the relationship of the parties and that they're going to resume having a relationship, the state would ask the court to impose the 12 months probation to be served in its entirety.
All right. Mr. Farmer, based on the allocution by the prosecution, does your client accept these terms?
Yes, Your Honor, there was previous negotiating and he does accept the terms.
All right. And do you stipulate to the factual basis venue and idea? I know Ms. Hutchins already asked you that and you indicated yes in accordance with the plea.
Yes, Sean, we do stipulate to the basis. I will ask that since he's been out on bail since 2021, he has adhered to all the conditions. He's been reporting for probation via email. We will ask if he can continue to report probation under the same terms.
He was reporting to probation prior to this?
To the
Pre-trial, that was
Pre-trial.
probably pre-trial, probably
Yes, Your Honor.
pre-trial.
And where does he reside?
He's here in Georgia, Your Honor, but I believe he's a truck driver. He's present too, Your Honor. We can ask him for an update on his current location.
All right, Mr. Wharton, this is the once a month reporting to probation. What's the issue?
Yes, ma'am. His name is Bruce Romanoff. I report to him every 15th of the month.
No, all right, that's a different office. Now we're talking about probation.
Okay. What was your question again?
What is the issue with reporting in person once a month?
Oh, I just was hoping that I could still just report via email the way that I was doing.
No, this is a domestic violence case.
Okay, well, there's no issue.
All right. So, Mr. Wharton, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
And is anyone forcing you or inducing you to plead guilty to battery domestic violence?
No.
And do you understand that if you are in the, if you are arrested again for the same offense in the future, that that second arrest would automatically be a felony matter?
Yes.
And are you satisfied with your attorney services?
Yes.
And has it been explained to you by counsel that if you decide to enter this plea and agree to the sentence, that you will not have a right to an appeal from this case, that you will not have a trial in this case, you will not be in a courtroom to confront your accuser, examine and challenge the state's evidence against you, examine witnesses, present any defenses you may have, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of battery family violence?
Guilty.
Sentence is 12 months to be served on probation. You will report to probation once a month in person, beginning with your first reporting date being August 11th before 3 p.m. And that report will be at 132 Mitchell Street in downtown Atlanta. While you are on probation, you will complete 40 hours of voluntary community service that can be done at any nonprofit 501c agency or business, but it cannot be a school and it cannot be a religious organization like a church or a temple. You are to begin, if you are to enroll and begin your domestic violence intervention program classes, and you must be enrolled within 60 days from today. You will complete the classes at your own expense. At all times while you are on probation, you are to have no further violent contact with Davika Wharton. Since this is a battery family violence conviction, you are to relinquish possession of any and all firearms that you possess. You cannot have a firearm in your home, on your person, in any vehicle you occupy, or anywhere near you. You have to surrender all firearms to law enforcement for destruction.
Ma'am, may I say something?
You may.
Judge, I'm a truck driver and I go out of state sometime, and I mean, there was no weapons involved in this at all. And
Mr. Wharton, a conviction for a domestic violence battery charge disqualifies you from the possession or the legal right to own a firearm.
okay, I understand.
If you are found in possession of a firearm and they see this conviction on your record, well, you'll be calling your attorney again.
I understand.
And Your
Okay.
Honor, for the record, Judge, I do see that that was not on the plea paperwork. But of course, by operation of law, the state was going to request that the court include that in the order. But thank you, Your Honor. I see the court has done that, even though it's not indicated on the plea paperwork.
It's indicated now.
Yes, Judge, thank you.
All right, that concludes this hearing. Mr. Wharton, you have to report to probation next Thursday. Thank you. Mr. Palmer, anything else, sir?
No, that's all for now, Your Honor. If you could be, we could be excused.
Yes, sir. Mr. Palmer, Ms. Redden is going to email you a form to fill out for probation so they can have that information in advance.
Understood, Your Honor.
Thank you, sir. You all have a good weekend. Thank you. Mr. Alvarado, please come forward to the podium over there. Waiting on paperwork for Bagley and Connie.
He has it now.
Mr. Bagley? Okay, this is position number 1 at our 1:30 calendar for State versus Benjamin Alvarado, case number 21 CR 003-535F, in which Mr. Alvarado was originally accused of improper erratic lane change, hit and run, failure of the driver to stop or return to the scene of the accident. These are the 2 charges pending against him. And Mr. Alvarado, you've been advised of your right to remain silent about the facts of the case, as well as your right to counsel. You've decided to represent yourself. Would that be correct?
Correct.
And you've read through the document with regards to the rights that you'll be waiving and the benefits you would receive with respect if you choose to have counsel.
Yes.
So you are voluntarily waiving the right to counsel. Right to name. Accusation number. Okay. Mr. Alvarado, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth, best of your knowledge? Thank you. All right, this is going to be a negotiated plea hearing, and Ms. Riley, what are the terms of the offer?
Yes, Your Honor. For the failure to maintain lane, it is 12 months probation, a $200 fine. For the driving hit and run, 12 months to serve 2 days, credit for time served 2 days, the balance on probation, a $500 fine, and restitution of $500 to the victim.
Mr. Alvarado, have you agreed to these terms?
Yes.
And do you understand that you'll be on probation to pay a $700 fine?
Yes.
In addition to probation fees and court costs and surcharges?
Yes.
And you also understand that you have to pay an additional $500 to your probation officer, and those funds will then be transmitted to the victim in this case?
Yes.
As restitution. Do you agree that the defendant charged in this case is you?
Yes.
Do you agree that this offense occurred in Fulton County, Georgia?
Yes.
And do you agree that the facts as alleged by the prosecution in their pleading documents are true and correct?
Correct. Yes.
Mr. Alvarado, have you consumed any medication or alcohol?
No.
And when you were reviewing these documents, were you able to understand the rights that you're waiving?
Yes.
And are you able to understand the proceedings so far?
Yes.
Is anyone forcing you to take this plea today?
No.
And when you were reading these documents, did you understand that if you enter this plea today, that you will not have a trial?
Yes.
You will not confront your accuser, challenge the state's evidence, present any defenses you may have, examine your own witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of driving with an improper erratic lane change and hit and run failure to return to the scene of the accident?
Yes.
On the failure to maintain lane is 12 months to be served on probation and pay a $200 fine, plus any court costs and surcharges. On the hit and run failure to return to scene of accident, it's going to be 12 months to be served on probation concurrent. You'll be paying a $500 fine and also a restitution. I'm sorry, you'll be served on probation, serve 2 days, credit for time served 2 days. The remainder will be on probation concurrent, where you will pay restitution in the amount of $500. Once all your fines and your surcharges and probation fees are paid, then your probation will be non-reporting. So if you've paid all your fines, then your probation will be non-reporting, okay?
Yes.
Your first probation visit will be next Thursday before 3 p.m. at 132 Mitchell Street. Before you leave, you need to fill out the probation form. We'll give that to you. Make sure you fill out all the information, and we will give you a copy of it. The address of the probation office is at the top.
Thank you.
Any question? Mr. Gaither, yes,
I have a few announcements, Judge.
you may proceed.
Position 7, we have a negotiated plea, just waiting for the trial to send us the paperwork. Position 12 and 13. Both of these cases, Judge, the state has requested the video, the body cam video for both cases. They haven't received it yet, and I can't advise my client without it.
Oh, just 1 second.
Oh, sure.
Mr. Alvarado? Mr. Alvarado? Oh, he did? Okay, then disregard. Okay, thank you. I'm sorry about that. I was thinking he left without filling out the probation.
Oh, okay.
Sorry about that.
No, no
2013, what was the issue?
The body camera video has been requested by the state for both cases. And I'm not here kicking and screaming, jumping up and down like the other lawyers are. I'm just asking, can we just place this case, his 2 cases, on the next final plea calendar to give the state an opportunity to receive the video so I can get it, show it to my client, and I can advise it.
Is there such footage?
That was my understanding. They've requested it, but they just haven't received it yet.
Ms. McCutcheon?
Which number was that?
Riley,
I think
it's
it's
Ms.
Riley's.
Riley. I do show that for position 12, that we have requested a video. We're waiting on a video. I do not see any notes regarding a video for position 13. So there is a video for position 12. I am not sure about position 13.
All right. I'll reset this case to a final plea calendar for September 8th. And that would be at 1:30 p.m. And if there's any video for position 12, it has to be shown to defense at least before the next final plea calendar.
Yes, Your Honor.
Mr. Francois, is he free to leave, Judge?
Here you go. Mr. Francois, you have to come back to court on September 8th at 1:30 p.m. Please keep in touch with your attorney. If your counsel has seen the video, maybe he'll be able to advise you the next step.
Yes, ma'am.
All right, you're free to go.
And I did, Mr. Gaither, email you the plea paperwork for position 7, Daryl Ford.
Okay, thank you.
Welcome.
And one more announcement, Judge, position 23, Mr. Derek Walker, that will be a plea today. Ms. McCutcheon, I sent you a little message in the chat. Did you get a chance to look at it? Because I know you was in the middle of a plea.
And then I was in a breakout before that. No, I've not, but I'll look at the chat. I'll look at the chat now.
Okay.
So do you have the plea paperwork or do I need to send it to you?
Yeah, you got to send it to me, or I could find a hard copy and I can fill it out, whatever's needed.
Well, Judge, can Mr. Gaither and I go into a brief breakout room, Your Honor?
Okay, but the plea paperwork can be sent to Ms. Redden. She will print it up for counsel and defense to review it. Okay.
Yes,
and
Judge.
Mr. Gaither can go into a breakout as soon as he picks up his laptop and steps
Yes.
outside. Okay, all right. Give me the final, what's the status of position 23?
That's going to be a plea, but that's the case that Miss McCutcheon wants to have a quick chat,
Okay.
chit chat about.
Okay.
Yes, because I'll need to prepare that. If I can just have a few moments. The only issue is the credit for time served. And as an officer of the court, Mr. Gaither, I can't verify what went on at the Atlanta Detention Center. We don't have access to that system. So I'll just go with what you say as an officer of the court.
Okay, and I'll tell you what, for the record, I'll tell you where I got the information from. In the discovery information, it shows that he was arrested at the city of Atlanta on the day of the incident. And then, and that was January the 4th of 2020. And then the bonding company didn't even set up a letter and post a bond until January the 6th, 2 days later. And that was like at 9 o'clock at night. And then he didn't get out until later on, either later that night or the next morning. That's why I said he served at least 2+ days.
Okay, and that's position 23. So I will prepare the paperwork and I'll send it to Ms. Redding, Your Honor.
Okay.
Okay, thank you.
Okay.
And then that was your,
So that was the discussion right there.
okay, so you are taking your laptop to have a breakout with Ms. McCutcheon?
I think that was the discussion right there.
Oh, that was it?
Yes.
Okay. So
That was the discussion. Mhm.
all right. Okay. So we're doing a plea on position 7 and 23, subject to the documents being reviewed with your client.
Absolutely, Judge.
All right. And Ms. Helen, before I take up my next plea hearing, do you have any announcements?
Yes, I do, Judge. For position 16, that'll be a plea, Your Honor, and we are prepared. We didn't receive DocuSign paperwork because it wasn't negotiated prior to court, but I do have old-fashioned plea paperwork here if that would be accepted, Your Honor.
Old-fashioned, I guess that's how we're referring to it now. Okay. For Ms. Helen, this is position number 16.
Yeah, the problem with that, Judge, the old-fashioned way is that the state prepared the plea paperwork the old-fashioned way. Even though I know the old-fashioned way, we prepared it and we handed it via hand, personal delivery. But I would have to prepare it so that I can at least indicate that I've put the input the plea rec and that I've signed it, and then I'd have to send it to the case manager the same way that I'm going to do for position 23. So
Okay,
Ms. Helen, I'll need to do that for 16 and 23.
16 and 23, waiting on plea paperwork from the prosecution. Okay. Next announcement.
For position 7, Judge, I'm going to ask for a reset. Ms. Ponder is present here in court. I was in the
Stop again. Position 1.
17.
Oh, 17.
Ms. Ponder.
7.
Sorry.
Okay, 17. Jaquila Ponders. I thought that was going to be a plea.
Judge, it was, but the DocuSign that Ms. Reiser sent was not the one that we were negotiating. We had sent some mitigating factors, some completion of some courses, and we expected for it to be either a different charge than what showed up to the DocuSign. And I know that Ms. McCutcheon can agree to change any DocuSigns that have been sent. So I prefer to just continue to negotiate with Ms. Reiser. I think by the next court date, if Ms. Reiser is not offering essentially what we're negotiating about, we would have a resolution, Judge.
What did your client think the terms of a plea were?
Well, Judge, we were negotiating possibly for a reduction.
And I'll just say, if Ms. Reiser sent the DocuSign paperwork and there was no indication of reduction, then that would indicate that Ms. Reiser was assuming, I would guesstimate, that the plea was to DUI. But since I can't speak for Ms. Reiser, Judge, I have no indication that it was a reduction. The DocuSign doesn't indicate that it's a reduction, but if Ms. Helen wants to reset it to speak personally with Ms. Reiser, then the state's not going to oppose, even though the case is very, very old.
I am first going to ask, were there plea documents that were submitted and signed by both the state and the defense?
No, Judge. I received.
Signed.
Not by the defense, Judge.
Not by the defense. Okay. And the documents that you have from Ms. Reiser, what do they indicate?
DUI less safe, a failure to dim lights, and possession of an open alcohol container.
And if I could just ask Judge, Ms. Kellen, because what my understanding of the plea offer was going to be 12 months served 24 hours, credit for time served, balance probation, standard first DUI, $300 fine, 40 hours of community service, alcohol, drug evaluation and treatment, risk reduction, 1 VIP, $200 fine as to the open container, and to null pros the failure to dim lights. Is that what's indicated on the DocuSign paperwork?
I don't have it, so
I'll put it up here. Give me 1 second.
Well, Judge, apparently there's not a meeting of the minds, so the state would not oppose a reset in this instance, since Ms. Reiser's not here to communicate to Ms. Helen whether or not she would accept something other than a plea to DUI.
I don't see any difference between what Ms. McCutcheon is offering and what Ms. Reiser is offering. What the defense is asking is that they want an opportunity to renegotiate.
Correct,
Or
Judge.
additional time to renegotiate and see if they can get a reduction. Is that correct?
Correct, Judge.
The request for a recess is denied.
Understood, Judge. I'll just speak to Ms. Ponder.
Okay, thank you.
My next announcement. I believe that's it, Judge. Oh, position 26, Ms. Wembley, that's going to be a plea, so I guess the state will have to send me that plea offer. But Judge, I would like it to be non-negotiated.
Okay.
Well, if it is non-negotiated, then the state would not send any plea paperwork. And Your Honor, for the record, the offer that was emailed, Ms. Reiser indicates she offered 12 months probation, 12 anger management classes, no further contact with the victim, and a stay away from the incident location. If it's non-negotiated, then there's no plea paperwork, Ms. Helen, for me to present to the court.
And I do have that plea paperwork filled out for Ms. Wembley in front of me.
All right, so we'll have a non-negotiated plea for position 26, and that would be for Deanna Wembley. All right, so I'm expecting a plea paperwork for position 7, position 23, position 16, and for position 26, it will be from the defense. And for Ms. Ponder, position 17 is a big question mark. So that brings us to Mr. Bagley. All right, Ms. Wiley, are you available to address position 3? Just a minute, I just need the prosecutor to appear. Oh, there she is. Okay. Mr. Riley, we are addressing position 3 on the 1:30 calendar. This is State versus Courtney T. Bagley, case number 21 CR 0031552F. Mr. Bagley was originally accused of 2 counts of willful obstruction of the law enforcement officer. This was from November 20th, 2019. Mr. Bagley, you've been advised of your right to remain silent, and you've waived your right to counsel. You've reviewed the documents, and you've understood the consequences of representing yourself and waiving your right to counsel.
Yes, ma'am.
Are you still abiding by that decision?
Yes, ma'am.
All right. Mr. Bagley, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Riley, what are the terms of the plea offer?
Yes, Your Honor, is to plead to 1 count of obstruction of law enforcement officers, 12 months on probation, a $300 fine. The balance of probation is suspended upon payment.
And count 2 is going to be null pros?
Yes, Your Honor.
All right. Mr. Bagley, you printed your name. Would you be able to please sign it?
All right.
All right, I just want to make sure. Yeah, you signed it in all the right place, but. Just a big X, right? All right. So with regards to this case, Miss Riley's indicated that this is going to be to one count of obstruction. Would you be paying the fine today?
No.
Okay. Mr. Bagley, in order for me to proceed with this plea hearing, do you agree that the identity of the defendant, the location of the offense, Fulton County, and the facts supporting this one count of willful obstruction are truly correct?
Yes.
All right. And have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
And is anyone forcing you or inducing you to take this plea today?
No.
And you've read through the documents in addition to the waiver of counsel. Did you understand that you also be waiving your right to challenge this charge in a court of law?
Yes.
Will not be a trial. You will not confront your accuser. You cannot challenge state's evidence. You cannot examine witnesses. And you cannot have the opportunity of having the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to waive all these rights?
Yes.
How do you plead to one count of willful obstruction of a law enforcement officer?
Yes.
Sentence is 12 months to be served on probation. You'll report to probation next Thursday,
All right.
the 11th of this month, before 3 p.m.
Okay.
And once you report, you'll be placed on probation to pay off this $300 fine plus any court costs and surcharges.
Okay.
You'll also be assessed probation fees. So the longer you take to pay off the fine, the more probation fees you have to pay. Once you pay off the probation fees, the probation will terminate.
Okay.
All right?
All right.
Once you pay off the fine and any outstanding probation fees, your probation will terminate.
Okay.
Any questions?
No.
Have you filled out the probation checklist form?
Yes.
All right. So here's a copy of this, the address and the phone number at the top. Report there. Today is Friday, so you report there next Thursday before 3 p.m.
Okay.
Thank you.
All right. Thank you.
Yes, Mr. Bagley. Thank you.
Your Honor, we going to take Mr. Ford's plea on the written paperwork from Mr. Ford.
Okay.
Okay.
We're going to address position number 7 on the 1:30 calendar.
It's a long day, yeah. Been a long week.
This is State versus Darrell Ford, case number 18 CR 34803, in which Mr. Ford was accused of simple battery domestic violence. I'm assuming the cruelty method is going to be non-pros, is that correct?
That's my understanding, Judge.
Yes. Okay. Mr. Ford, you've been advised of your right to remain silent, and your attorney is Mr. Frank Ginsberg.
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Take hands out of the pockets. All right. Ms. Riley, what is the plea offer for Mr. Ford?
Yes, Your Honor, it is 12 months probation, 6 anger management classes, to have no further violent or harassing contact with the victim, Shakiria Houghton.
Any objection to non-reporting or terminating upon completion of the anger management process?
No objection, Your Honor.
Okay, so I may terminate it?
Yes, Your Honor.
Okay. Mr. Gaither, does your client accept the terms and do you stipulate to the factual basis venue and ID?
Yes, we do stipulate to the factual basis, venue and ID. We stipulate, we agree to the terms, and I was gonna ask the court, I forgot to mention that with the prosecutor, about the termination of the probation, because he and the young
He's
lady.
agreed to terminate.
Yes, thank you.
Yes, this is his first arrest.
Last.
That's right.
Okay, Mr. Ford, have you consumed any medication or alcohol?
No.
And have you understood the proceedings so far?
Yes.
That's fine with your attorney.
Yes.
Is anyone forcing you to take this plea out today?
No.
And also, has your attorney gone over your waiver of rights, including your right, including the waiver of your right to trial?
Yes.
To confront your accuser, to have a counsel's assistance so that you can challenge the evidence and witnesses brought before you?
Yes.
And also the right to have the state try to prove the charges against you beyond a reasonable doubt.
Yes.
Are you doing so freely, willingly, and knowingly?
Yes.
How do you plead to one count of simple battery domestic violence?
Yes.
Sentence is 12 months reserved on probation. You will complete 6 anger management classes while you're on probation. You will need to start those classes within 60 days from today.
Of course.
And while you're on probation, you have to have no further violent contact with superior improvement. You report to probation next Thursday before 3 p.m. And if you complete the classes and you don't get arrested and there are no issues with Ms. Hooten, then your probation will terminate.
Right on. Thank you.
And I'm sorry, Your Honor, I apologize if I did not hear this. Mr. Gaither and I had discussed this being under first offender. And I
didn't hear that.
Okay. I just didn't know it, because if it's under first offender, of course, he would have to remain on probation. But since it's not, then I still don't have an objection.
Okay,
I went with
I was,
termination because I didn't hear first offender.
I'm sorry, and I was filling out his probation form. I was taking the plea, so let me
Can
start.
only multitask.
I'm sorry.
And
I'm tired now, Judge. I'm sorry. So yes, this was a first offender plea. And so if the probation must continue, then we ask that at least be non-reporting at some point, because what I was gonna say is that my client and the young lady do have 4 children together. And I'm trying to keep as much money in his pocket so he can make sure the babies are taken care of.
Do you want to confirm with him the difference between terminating his probation or being on non-reporting?
I have. We've had that discussion almost ad nauseam.
And I don't have an objection to non-reporting, but if he is pleading under first offender, he would have to complete the entire probation period.
Mr. Ford, are you amending your plea to guilty under the First Offender Act?
Yes, I understand totally.
So your probation will not terminate upon completion, but it will be non-reporting upon the completion of the condition.
No doubt. Agreed.
Okay, and that concludes this case. Thank you.
Thank you, Judge.
All right, Mr. Gaither, hope you get a cup of coffee between now and the next case. All right. Those folks out there, are those your clients as well, or is that just your 2 people? The lady in the pink shirt, is your attorney, Ms. Rosenblumer? No, it's Attorney Helen. Miss Helen. Miss Helen? All of you, Miss Helen? Who? Oh, you're waiting to speak to?
I did already.
Okay. Oh, you did?
Yes, ma'am.
Okay. Ms. Rosenblumer, what are we doing for Mr. Cherry?
Yes, Judge, I am on the phone with ASG Riley right now. We're trying to work out the terms. It's a possible plea.
No problem. Just wanted to get an update. Thank you.
Yes. Okay.
Energy drink after this week. Jeez. For a month. proceedings.
So he needs to report by next Thursday.
4:30.
Judge, I do have a brief update.
Just give me a moment. We're just conferring another case.
Yes, Your Honor, apologies.
All right, thank you for that, Ms. Rosenhuber. Yes, your announcement?
Yes, Your Honor. For Antonio Cherry, that will be a plea. Miss Riley is going to work on the paperwork and she does have to amend the accusation. So she'll need time for that. And I figured, Judge, since my client's in person, that'll give me time to run down to the courthouse if the court will allow me to be out of court for about 15 minutes.
Right. Do you have any other cases besides Mr. Cherry?
Unless Mr. Batson pops back up, no.
Okay, we'll
Okay,
wait
thank
for you.
Thank you, Judge. I'll be there shortly.
Okay. Mr. Cherry, Ms. Rosenhuber is on her way. She's right up the street, so she'll be here. Ms. Riley, if you can submit the paperwork for Mr. Cherry too, appreciate it. Thank you.
Yes, sure, I'm working on that, but first I do have to amend the charge. So-
Got it. Ms. McCutcheon, we are about to address position 26, State versus Deanna Wimbley. Are you ready to proceed?
Judge, I was working on position number 23, Derek Walker.
It's just a non-negotiated plea and then.
Oh, okay, yeah, we can do that. I can do that, you Judge. I've completed this. I'm going to email it to Ms. Redden and Mr. Gaither at the State Orca email address
Okay.
right now. Okay.
Understood. Thank you. This is State versus Deanna Michelle Wimbley, 21 CR 0053329F. Ms. Wimbley is present with her attorney, Ms. Catrice Helen, and Ms. Wimbley is charged with simple battery from October 6, 2020 in Fulton County, Georgia. Ms. Wimbley, you've been advised of your right to counsel and your right to remain silent. This is going to be a non-negotiated plea hearing, which means that the prosecution is first going to tell me what their recommendation is if you decide to plead guilty, and then your counsel is going to give me an alternative recommendation. I'll consider both requests and then let you know my decision, keeping in mind that I have the right to also disregard either request and set this case down for trial. Okay, Ms. McCutcheon, excuse me.
Yes, Judge. On a plea of guilty to simple battery, the state's offer was 12 months probation, 12 anger management classes, no further contact with the victim, and to stay away from the incident location. Do you want to hear the factual basis, Your Honor?
Yes, for purposes of the non-negotiated terms.
Right. Okay. The state would expect the evidence to show, had the case gone to trial, that on October the 6th of 2020, East Point police officer was dispatched to 2991 Kentucky Court, apartment number 5, East Point, Fulton County, Georgia, in reference to a fight call. Observed 2 females upon his arrival, identified as Renika Jordan and Deanna Wimbley, the instant defendant. Both females were detained and placed in separate vehicles. Spoke to Jordan, and she stated that Wimbley came to her residence to pick up a Deontay Mitchell. Wimbley then got out of her vehicle, walked up to Miss Victim and flicked a cigarette at her, striking her in the chest. The victim, Renika Jordan, also stated that Miss Wimbley struck her in the right side of her face. However, the officer did not observe any bruising or marks consistent with her having been punched. However, there was a small hole in the victim's shirt that was consistent with a cigarette having been thrown at her. The officer then spoke as well with the defendant. And based on what the officer learned during the course of the investigation at the scene, he advised the officer advised Ms. Wimbley that she was being arrested, and then she was then booked and charged accordingly with simple battery for the conduct that she exhibited against the victim, Ms. Jordan.
Right.
That's the state's factual basis, Judge.
All right, any priors?
Your Honor, let me just see. Let me go back to another page, Judge, to look. She has a 2016 criminal trespass that was null prost.
Thank you. Ms. Helen?
Yes, Judge, this is a non-negotiated plea. As you've heard, Ms. Wimbley's history, she's not a long-standing violent offender. She is a proud mother of a 7-year-old son. She's a full-time worker at the Drive to Villas Healthcare Center. She's a lifetime resident of Fulton County, and parents are in Forest Park. Judge, we're asking for 2 anger management classes. The allegations are about a contact with a cigarette. Ms. Wimbley has grown since that moment. She's full-time employed, Judge, and she just wants to move on through this. And we feel that 2 anger managements full-time each class would be sufficient to go ahead and close out this case. And Judge, because of her history and also just because, just how well she's doing right now in her life, Judge, we're asking that once she completes those anger management classes, can it be non-reporting or terminated, Judge? We're asking for termination. I apologize.
All right, any response, Ms. McCutcheon?
Judge, the state would not be opposed to the probation being non-reporting, but we would oppose the probation terminating, since there is a victim involved in this case, and we want to make certain that the no contact and stay away conditions are upheld, and the court has authority over the defendant in that regard.
Any problem with staying away from Renika Jordan?
No, Judge, and for 3 years, Ms. Wimbley has had no contact with Ms. Jordan and hasn't been back to that location.
Okay, thank you. I'll accept the defense's recommendation. It will be 12 months to be served on probation with 2 anger management classes to be completed within 60 days from today. No further contact with Renika Jordan, and no illegal drugs, no alcohol, and no weapons. And upon completion of the anger management classes, her probation will be non-reporting.
Understood, Judge. And I apologize, Judge. We did ask for termination.
I know. I'm going to give you, I've knocked out 10 classes and I'm amending it to non-reporting.
Yes, Judge, we accept the court's decision.
Okay. Miss Helen, does Do you stipulate to the factual basis, venue, and ID?
We do, Your Honor, and we ask this court to accept the plea as negotiated here.
All right. Ms. Wembley, have you consumed any medication or alcohol recently?
No.
And before I'm going to ask you that question again, because I've got to place you on the oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. So no alcohol and
No
medication,
alcohol.
correct? And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea today?
No, ma'am.
And have you understood that if you decide to plead guilty today, there won't be any appeals, there won't be any trials?
Yes, ma'am.
You will not have the chance to confront your accuser, examine witnesses, challenge the evidence brought against you, examine and cross-examine witnesses who testify against you, and have the state try to prove the original charge against you beyond a reasonable doubt.
Yes, ma'am.
So how do you plead to one count of simple battery?
Guilty.
The sentence is 12 months to be served on probation. You will begin probation next Thursday before 3 p.m. and you report to 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 2 anger management classes and they must be completed within the next 60 days.
Okay.
After you've completed probation, after you completed the classes, your probation will be non-reporting.
Okay.
You are to have no contact with Renika Jordan, stay 200 yards away from her and do not communicate with her in any way, form or manner.
Yes, ma'am.
Thank you.
Thank you. And Judge, we be ready on Ms. Miller as soon as I can get that DocuSign.
Okay, thank you. We had the cover sheet. Because we just make a copy of one of them.
Yeah.
Yeah.
And Your Honor, just so I'm clear, I know Ms. Helen has positions 16 and 17. My notes show that the paperwork was already submitted on position 17. Does the court have that?
No.
So the court does not have 17?
Position 17, there is no commitment to take a plea because Ms. Ponder is looking for a reduction from DUI.
That's correct. That's right, Judge. I'm working on position 16 now then as we speak. Thank you.
Okay.
You're muted, Your Honor.
Hear me. Ms. McCutcheon, I'm so sorry, may I interrupt for you to address a plea for position 17, Shakila Ponder?
Yes, Your Honor. Mhm.
Thank you, appreciate it. Okay,
So Ms. Ponder is going to take the plea?
yes, I don't know, I'm going to let Ms. Helen describe what we're doing.
Yes, Judge. Mhm.
Judge, this will be a plea. We're just accepting the terms from the state, but Judge, we're asking for a financial hardship waiver form, if that can be provided by the court to Ms. Ponder. And then we're also asking for that first time DUI conviction affidavit, the temporary driver's license.
What are you asking in terms of the financial hardship?
So, Ms. Ponder, you may have to give a little bit more detail than I can. In 2019, this is when this case occurred, Judge. In 2020, the entire year, she had an interlock device.
2019, I had my license. When I got pulled over, they took the license. I had a 1-year hard suspension. In order for me to get a limited permit, they required me to get an interlock device installed in a vehicle, which I did. I had it installed for 8 months. And after the 8 months, the car got repoed and there was no insurance on the device. So in order for me to finish out the 4 months, I would have to get it reinstalled in a car, which I'm not driving at the moment. So there's no way for me to get another device to provide the DMV with the 12 months of the interlock installation. So the only other option that they gave me is to get a financial hardship waiver to lift that suspension for this case.
Oh, I see. I see what you're saying. You just want a financial hardship, so they'll lift the suspension by DPS.
Yeah, because there's no way for me to.
Understood. Okay. And do you have the form for that?
I do not, Judge. That was my first time hearing about the form. I thought the court would provide it. The DDS doesn't have
The Department of Driver Services furnishes those forms, and then you would have to come down. Yes, they do. I've signed them. All right.
I went there.
The other option is to go up to the clerk's office and ask Mr. Michael Jordan for that form, because it's a financial hardship form. Basically, what they're saying is that you're waiving all the fees in order to lift the suspension on the driver's license. That's what it is.
The waiver, is the waiver gonna put another suspension on the license? Because I already served the 1-year hard suspension, okay?
You're getting an affidavit of first conviction, so you're gonna get a limited driver's license.
For how long?
This will be, I think, if I'm not mistaken, it will be up to 4 months.
What floor is Mr. Jordan on? Would I be able to walk her, walk her down there to get that form?
The clerk's office. Okay.
You don't have a birth offender? What is
Don't
it?
have it. I don't know what to tell you. I know the form is furnished by, yeah,
All I
we'll
need is a
go
form from here, that's all.
We'll
Wherever
go
I go.
after Judge to the first floor and visit Mr. Jordan.
all right. Are we ready to proceed?
Yes, Judge.
This is State versus Shakila Ponder, who was originally accused in case 20 CR 3881C with failure to dim lights, DUI, driving under the influence of alcohol less safe, and possession of an open alcohol container. This was from a December 1st, 2019 incident. Ms. Ponder, you've been advised of your right to remain silent, and you are represented by counsel, Ms. Patrice Helen. This is going to be a negotiated plea hearing, so Ms. Ponder, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
If any point during this hearing, you decide that you change your mind and you don't want to take the plea, you let me know. Okay?
Give us 1 second. Calendar. We're ready, Judge.
Ready? Okay. So, Ms. McCutcheon, could you please let me know of the state's recommendation?
Yes, Your Honor. The state's recommendation on the plea of guilty to driving under the influence of alcohol less safe would be 12 months probation, a $300 fine. It's the standard, Your Honor. Let me go back. I don't have the plea paperwork since it was previously submitted.
May I repeat this and you tell me?
Yes,
if it's
Judge,
all
because
right?
and I don't have DocuSign to access it. Yes, Judge.
The plea paperwork indicates that it will be 12 months to serve credit for serve 1 day, credit for time served 1 day, balance probated. While on probation, she will pay a $300 fine, complete 40 hours of community service, complete an alcohol and drug evaluation and any treatment that's required, a risk reduction program, and attend one victim impact panel. I'm granting the defense's request for an affidavit of first conviction, and I will sign the waiver of fees in order to have her license reinstated.
Okay. Thank you, Your Honor. And that is what Ms. Reiser's notes to me indicate. I just didn't have the actual document that the court has in hand to make certain that my notes from Ms. Reiser are consistent with what is depicted on the document, and it is. The state would expect the evidence in this case to show, Judge, that on the incident date of December 1st, 2019, law enforcement officer with the Fairburn Police Department observed a vehicle traveling with the high beam lights on. The officer conducted a traffic stop, came into contact with the driver identified as the defendant, Jaquila Ponder, before the court today. The officer smelled the odor of alcohol. The driver of the vehicle, the defendant, had slurred speech and glossy eyes. The officer asked her to participate in some field sobriety tests, to which she complied. And based on her performance of those field sobriety tests, the officer determined that she was less under the influence of alcohol and less safe to drive a vehicle. The officer asked if she would submit to the Alka sensor. She submitted to the portable device, which tested positive for alcohol. She was then arrested and charged accordingly. During a search of the vehicle incident to the impounding of the vehicle, an open container of an alcoholic beverage was found in the vehicle under the driver's seat. Do you stipulate to a factual basis, counsel, for a plea to open container and driving an alcoholic beverage and driving under the influence of alcohol less safe?
We do so stipulate. We just ask this court to accept the plea as negotiated.
And Your Honor, I will submit a null pros order. I will email it to Ms. Redding for the failure to dim lights.
Okay. Ms. Ponder, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
No.
If you don't understand the proceedings, I'm going to stop it at this point so you can ask your attorney any questions. All right, while Ms. Ponder is debating proceeding with the plea, Mr. Gaither, we can proceed with position 23, State versus Derek E. Walker. Ms. McCutcheon, sorry to switch hats, but we are moving to position 23. This is case 21 CR 6401F, in which Derek E. Walker is accused of the following 6 offenses: DUI, driving under the influence of alcohol less safe, reckless driving, impeding traffic flow, possession of an open alcohol container, failure to turn on the headlights as required, and operating a vehicle with an expired tag or unregistered vehicle from January 4th, 2020 in Fulton County, Georgia. Mr. Walker, you've been advised of your right to remain silent, and your attorney with you is going to be Mr. Frank Gaither. This is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I will, yes.
Yes?
Yes.
Okay. I understand that this will be a plea to the offense of driving under the influence of alcohol less safe and possession of an open alcohol container, correct?
That's correct, Judge.
All right. Now let Ms. McCutcheon indicate the disposition of the 4 other charges.
Yes, Judge, I will email a null pros order to the court for the offenses of reckless driving, impeding traffic flow, headlights not turned on as required, and expired tag on a registered vehicle upon a plea of guilty to driving under the influence of alcohol less safe and open container violation.
All right.
Go
ahead.
Yes, Judge. Had this case proceeded, first of all, Judge, let me just articulate for the court the state's recommendation. The state would expect the evidence to show that this is a 2nd and 10 driving under the influence, would be a 2nd and 10 driving under the influence of alcohol conviction for the defendant. The state's recommendation would be 12 months to serve. As the court knows, the court can suspend all but 72 hours of the 15 days. So 12 months to serve 72 hours, credit for the time served. That was a discussion counsel and I had, and as an officer of the court, counsel has indicated that he did review in the discovery that the defendant was released 72 hours after his arrest. So the state will give credit, recommend credit for that time served. A fine, $300 fine, $300 fine. The balance of the 12 months on probation, the $300 fine, 240 hours of community service. And Mr. Gaither, I had to look at the statute. I don't think on a 2nd and 10, that's a lawful fine. I'm looking at that fine amount that was previously recommended, but Judge, I'll look into that, but I don't think that's a lawful fine for a 2nd and 10, but I'll look at that. Alcohol and drug evaluation and treatment, a risk reduction program completion, 1 victim impact panel, and on the open container, a $200 fine and 12 months probation concurrent with any sentence imposed in the count for DUI. The state would expect the evidence to show had the case gone to trial, but on the incident date of January 4th of 2020, Officer Jay Cowens with the Georgia State Patrol was traveling. I'm sorry, Judge, this is actually, look. This is an Atlanta Police Department. Officer Collins with the Atlanta Police Department was traveling and responded to an auto accident at I-20 eastbound and Lee Street in Atlanta, Fulton County. Spoke with a Mr. Michael Landrum, who indicated that he was traveling on I-20, came into contact with a vehicle that was driven by the driver being identified as this defendant, Derek Walker, who was parked in the second to the last lane from the center divide. And the witness struck Mr. Walker's vehicle because it was improperly parked on the roadway there on I-20. Coming into contact with the driver, Mr. Walker, the officer smelled what appeared to be the odor of alcohol coming from his body. The officer asked him to perform some field tests. It was obvious based on the officer's observations that the defendant was struggling, not able to perform those field sobriety tests, was unable to follow the officer's command. His body was swaying from left to right. He was shaking. He was then placed under arrest for driving under the influence of alcohol less safe, as well as reckless driving. An open container was found of alcoholic beverage was found in the vehicle. He was charged with that, as well as the other traffic citations. His vehicle was stalled and he was impeding traffic there on I-20, which caused the other motorist to collide with his improperly stopped vehicle on the roadway that had impeded that traffic. The officer placed him under arrest and he was charged accordingly, Judge. And also the registration, Your Honor, the officer determined that in addition, the tag and registration of his vehicle had expired. And he did not have the headlights turned on as required, according to the information that was provided by the witness who struck the defendant's improperly stopped vehicle in the roadway. And that is the factual basis. And counsel, do you stipulate to a factual basis for this plea to driving under the influence of alcohol less safe and possession of the open container of an alcoholic beverage?
Yes.
And Your Honor, as I said, this would be a 2nd and 10 driving under the influence. And I'm going to check, Judge, the statute.
600.
Okay, thank you, Judge. And Mr. Gaither, even though the state's recommendation is 300, that is not a lawful, statutory lawful sentence for a second.
I understand. Can we transfer the $200 fine from the open container, transfer that to the DUI and make that a 600? I'm saying, can we eliminate
Judge,
the $200 fine?
Yes,
from the
Judge,
open
the
container?
state will revise the recommendation, a $600 fine on the driving under the influence and the just 12 months probation on the open container concurrent with the DUI sentence. So striking the $200 fine for the open container.
Okay. And Mr. Gaither, based on that renegotiation, does your client accept the terms and do you stipulate to the factual basis, venue, and ID?
Yes, we agree to the terms, Judge, and we do stipulate to venue, ID, and factual basis.
All right. Mr. Walker, have you consumed any medication or alcohol recently?
No.
And have you understood that this is going to be your second DUI conviction, second lifetime conviction? or second and 10.
Yes.
And if you have a third one, all the numbers just keep going up.
Okay,
They just go up higher and higher and higher.
I understand.
And actually for community service, they say not less than 30 days of community service. So
And Judge, typically, the state will calculate that as 30 days, 8 hours a day, 240 hours. If the court wants to draft it as 30 days, I have seen prosecutors do it both ways, 30 days or 240.
I understand. I'm just trying to explain the ramifications if there are any subsequent DUIs.
Okay,
All right. Right now, I'm accepting the state's position of 8 hours a day for community service for 30 days. The court doesn't have to accept that. Do you understand, sir?
yes,
I'm just trying to re-emphasize that the numbers don't go down, they go up.
okay,
And Mr. Walker, if you decide to plead guilty to your second DUI charge, you would have to give up your constitutional right to a trial, to go back to court and face your accuser, challenge the state's evidence, be able to present any defenses if you choose to do so, examine witnesses, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
Are you satisfied with your attorney's representation?
I am.
Is anyone forcing you to take this plea? So are you doing so freely, willingly, and knowingly?
Yes,
How do you plead to one count of DUI less safe and one count of open alcohol container?
guilty.
On the DUI, it's going to be a 12 months to serve 72 hours, credit for time served 72 hours. So you have no additional jail time.
Okay,
You'll be placed on probation. You report to probation next Thursday at 132 Mitchell Street before 3 p.m. While on probation, you will complete 240 hours of community service at any nonprofit agency, which is not a school and not a religious organization.
okay,
You have to pay a $600 fine, and you have the rest of the 12 months to pay off that fine. And that would also include any surcharges and court costs. You have to complete an alcohol and drug evaluation and submit yourself to any treatment that's required by the evaluator, a risk reduction program, attend and complete one victim impact panel. You report to probation every month, and you will be subject to random screens for alcohol consumption.
okay,
While you're on probation, you're not to consume any alcohol. No alcohol beverages.
okay,
With regards to the open container, your sentence is 12 months to be served on probation concurrent to the DUI sentence. The remaining charges will be not crossed by the state.
okay,
And Your Honor, I just emailed the null pros order for those remaining charges to Ms. Redden and the state Orca email as well, and copied you, Mr. Gaither.
okay, thank you.
Thank you. The probation document has to be completed before Mr. Walker may leave, and then he reports next Thursday before 3 p.m.
And that's been completed, he just needs a copy of it.
All right, thank
Okay,
you.
thanks.
Thank you, sir. Ms. Ponder, Ms. Helen, have you made a decision?
Judge. Yes, Judge.
And what is it?
We're gonna go through with the plea, Judge.
All
Just some clarifying points there.
Okay, as we were saying, Ms. Ponder has understood the proceedings so far?
Yes,
And have you satisfied with your attorney?
yes,
And have you, is anyone forcing you or inducing you to take this plea today?
no,
And Mr. Ponder, you've gone over the documents with Ms. Helen. Do you understand that if you decide to plead guilty to this charge, it will be a first and lifetime DUI conviction on your record?
yes,
All right. And do you understand that you can't appeal from this decision?
yes,
And if you decide to plead guilty, that you will not have the opportunity to have a trial in front of a judge or jury, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to one count of DUI? Let's see.
Guilty.
How do you plead to one count of failure to dim lights and open container?
I thought they were dismissing the failure to dim lights. And
Oh,
it's
are
just
they?
open
Okay, I'm sorry.
containment.
It's listed up here, so.
Is that right, Ms. McCutcheon?
Yes, Judge, that was a mistake then. That should not be reflected. The state is going to move the court to null pros the dim lights.
Okay,
Offense.
then how do you plead to one count of open container of alcohol? Is that supposed to be null pros too?
No, Your Honor.
How do you
The
plead?
state's yes, Ms. Helen, that was on the plea form as a $200 fine.
Correct.
Actually, it's not.
It does not say $200 fine, Judge?
I didn't see the fine, but the charges
The
on there,
only thing
there's
is
no fine.
DUI, let's
No.
say, did y'all intend for her to plead to the open alcohol container?
Yes, Your Honor.
Well, Judge,
That was the offer that was communicated to counsel.
I don't believe so, Judge. Give me 1 second. I didn't see the open alcohol container on that plea form.
All right, Ms. Fonda, have a seat, and while we clarify the terms of this, because I thought it was only just null pros and dim lights. Okay. Mr. Antonio Cherry? This is position 4 on our 1:30 calendar, State versus Antonio Rodriguez Cherry Senior, case number 21 CR 5529F. Mr. Cherry is accused of battery domestic violence from an August 11, 2020 incident. Mr. Cherry has been advised of your right to remain silent, and your counsel is Ms. Rosenhuber. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Ms. Riley?
Yes, Your Honor.
To articulate the terms of, is he pleading to simple battery family violence?
Yes, Your Honor. The state has just amended the battery family violence count to simple battery family violence. I believe that Ms. Rosenhuber is waiving the defect due to it being a lesser included and being past the statute of limitations. But we did amend that charge. After my reading of the report, the victim had no injuries. There was blood mentioned, but it was the defendant's blood as he cut himself. And it was originally charged in the report as a disorderly conduct, and then a supplemental report was later added for it to be simple battery family violence due to Mr. Cherry placing his hands around the victim's neck. But there was no bruising or no visible injuries to the victim. Hence the reason for the amendment to simple battery family violence. They do.
And the terms of the sentence?
Yes, Your Honor. It is 12 months to serve 28 days, credit for time served 28 days, the balance on probation, 6 anger management classes. He is to have no further contact with Anisha McPherson. There is to be third party involvement to transfer the shared children.
Okay. Anything else?
No, Your Honor, that is all.
All right. Ms. Rosenhuber, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, we do, Judge.
All right. Mr. Cherry, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea today?
No, ma'am.
And has it been explained to you that if you decide to plead guilty to this charge, that you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury? You won't be able to confront your accuser, examine witnesses, challenge the evidence brought against you, have an opportunity to present any defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery domestic violence?
Guilty.
The sentence is 12 months to serve 28 days, credit for time served, 28 days, balance probation. You have just over 11 months to serve on probation. While you're on probation, you will complete 6 anger management classes that must be started within 60 days from today. You have to have no contact with Anicia Merkson, staying 200 yards away from this person, and do not communicate with her in any way, form, or manner. You can use a third party in order to facilitate transfer and visitation of any shared children with Ms. Merkson. Okay?
Yes, ma'am. Yes, Your Honor.
Once you've completed the anger management classes, I'll allow your probation to be non-reporting.
Thank you, Your Honor.
So the sooner you're done, the sooner you'll save yourself on probation fees.
Thank you, Your Honor.
Any questions?
No, Your Honor.
All right. Your probation report is next Thursday before 3 p.m. at 132 Mitchell Street. We'll give you a copy of the probation document, and the address is at the top. Next Thursday before 3 p.m.
Thank you, Your Honor.
All right, Ms. Wright. This is the null process.
And Your Honor, are we ready to go back to Ms. Ponder? Judge, I just reviewed my notes again, but I will admit to the court has the document that was previously submitted. So I have the notes as to what should be, what the prosecuting attorney intended to place on the plea paperwork. I don't know if that was reduced to writing on the plea paperwork. What I have is the notes states that the open container was to be a plea and a $200 fine, and the failure to dim lights was to be a null pros. However, what was reduced to writing may be something different, but I don't have access to see that.
I can tell you what I'm looking at on the cover sheet, on the charges, it lists DUI less safe, failure to dim lights, and open container. So that's why I had a question. Are we pleading to failure to dim lights? But you had indicated that you're going to null pros that charge.
That's correct, Judge. Yes. So I should not, and I guess well, whoever prepared the paperwork, that should not have been included on the paperwork. Yes.
Okay. And then, which is not a problem. It's just me
Yes.
just crossing that out.
Yes, Judge. Thank you. Sorry for the confusion.
Then on the waiver of rights form, the only thing that is listed where the state has promised to recommend are the terms for the DUI less safe. There's no indication of any terms for open container. That's blank.
Is that signed by a prosecutor, Judge?
The one that I sent back was.
I don't have by Jordan Reiser on July 28th, 2023.
And so the only recommendation is for the DUI?
Those were the only terms filled out.
I'll just ask you, Ms. Helen, based on your email, your communications, because I don't have those emails, was it your understanding that of the 3 charges, at least one of them was going to be null prost?
From my
Oh,
understanding.
you have to be at the microphone, sorry.
Sorry, Judge. From my understanding, Judge, we had negotiations for a reduction for reckless driving. That was my last email with Ms. Reiser. So no, I don't have any notes that would suggest anything different than the plea form that was sent to me by Ms. Reiser on July the 28th, Your Honor.
There's no indication.
You can, the state can withdraw the plea, the defense can withdraw the plea, we can reset it for plea clarification, or we can.
Yes, Judge. Judge, I think we need to reset it for clarification. And I'll be candid with the court. Even though this is the first DUI, I'm concerned about the driving without a driving license prior history that I would have communicated to the court at the recitation of the state's recommendation before the state completed its recitation. So I think it would be best to reset it so that Ms. Reiser, so that the intent of both parties, both Ms. Reiser and Ms. Helen, are very clear, and there's a meeting of the minds. And since I'm not a party to that, Judge, I would not be willing to null pros both the open container and the failure to dim lights. Ms. Helen, I'm willing to null pros the failure to dim lights is what I had indicated the notes reflected, but since you were not, there was not a mutual meeting of the minds on that, perhaps it would be better to reset. Or if you want to proceed today, I will honor, in good faith, I have to, but it's my understanding that the failure to dim lights would be null pros, but there would be a plea to the open container.
I can reset it, and Ms. Ponder can appear via Zoom in order to address the plea. Ms. Helen, you already have the paperwork. The other option is that if she wants to plead NOLO to the open alcohol container, it will be a $200 fine suspended.
The state would not be opposed to that, Judge, and I would still null pros the failure to dim lights.
Okay. Ms. Helen is conferring with the client.
Yes, Judge.
All right, there we go. Thank you. Thank you.
Hey, Judge, we just have a clarification. Ms. Ponder did this last statement you made about the open container. What was that offer?
If she wants to plead no contest to the open container, it will be a $200 fine as recommended by the state, but it will be suspended, which means she doesn't pay the fine. The fine. Maybe you don't understand the language.
Originally, they're trying to charge you for a $200 fine. The judge is saying they're.
So the only fine you'll be paying is the $300 for the DUI. And ma'am, you're waiting on Miss Helen.
Ms. Miller, that's.
Oh, okay.
And Mr. Doster.
Mr. Who?
Doster, he's the last position. I believe he's outside, Judge. Gerard Doster. We'll go forward, Judge.
All right. So, Ms. McCutcheon, you will submit a null pros on the failure to dim lights.
I will, Judge.
So, Ms. Ponder, you are pleading guilty to one count of DUI less safe. Would that be correct?
Correct.
Sentence will be 12 months to serve 1 day, credit for time served 1 day, balance be in probation. You'll report to probation next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're in probation, you will have the rest of 12 months to pay the $300 fine, plus do 40 hours of community service at any nonprofit agency, which is not a school and not a religious organization. You'll also submit to an alcohol and drug evaluation and submit yourself to any treatment or counseling that's required by the evaluator. You also have to complete a risk reduction program and 1 victim impact panel. You may complete all these conditions anytime during the next 12 months, as long as they're completed before the end of the 12 months. How do you plead to one count of open alcohol container while operating a vehicle?
I'll
accept your plea of no contest.
And Judge, we just had one last thing, just non-reporting. We're asking if the state is amenable or doesn't have an objection that once Ms. Ponder completes these conditions, can the probation go non-reporting?
Yeah, I was going to go with that. Open container, and that's going to be a $200 fine, which is suspended. And this is a NOLO to the open container. You filled out the probation form?
Yes, I did, Judge.
All right, as soon as we have it, we'll make a copy, give it to Ms. Ponder. Remember to report next Thursday.
Understood, Judge.
And then once we get the affidavit of first conviction and the form for the waiver of the suspension fees, I'll sign those too. All right.
Pay the fine today.
Hmm?
Pay the fine today.
Yeah.
And Your Honor, I just emailed the null pros for the failure to dim lights to Ms. Redden in the state Orca email and copied Ms. Helen.
All right, great. Thank you. Okay, who would you like to start with next, Ms. Helen, Ms. Miller or Mr. Doster?
I'm filling out Ms. Miller's paperwork now. I received it. If Ms. McCutcheon could also send me Mr. Doster's paperwork.
Ms. McCutcheon, Mr. Doster, which is position 4, I believe.
That's Ms. Riley's.
Oh, sorry, Ms. Riley on position 4, Jawaria Doster.
Position 5. You said
5,
Doc?
I beg your pardon, 5, yeah.
Okay. I have that was supposed to be a pretrial with Miss Helen. I have not spoken with Miss Helen.
It was to get the offer.
Okay. I can certainly send the offer again that was emailed. It says on July 28th. It's a DUI, first DUI. So it's the minimums, statutory minimums.
Understood. And I also think I checked for Mr. Doster. He also would qualify for the first time DUI affidavit as well.
Okay. And so you need the paperwork.
Yes.
Okay.
I have it, Miss Riley.
You do have, okay, thank you.
Not the plea paperwork that, oh, you're talking about.
I was just with the affidavit.
Right.
I'm sorry, Ms. Redden, you were saying you have the affidavit, you don't have the plea paperwork.
Correct.
Okay, thank you.
All right, while Ms. Riley is doing the paperwork for, was it Mr. Doster and Ms. Miller?
Just Mr. Doster, I have Ms. Miller.
Okay. I have a gentleman here. What's your name, sir?
That's Mr. Doster.
Oh, that's Mr. I'm so sorry. It's been about 3 hours ago since we began. Okay. Ms. McCutcheon, you free or you working on something?
No, Judge, I'm waiting for, there's a plea on Miss Miller, Miss Miller's case. I think that's position.
Yeah.
16.
Yep.
Why do you need me to speak with someone, Judge?
With Miss Helen?
I'll be emailing that shortly here.
Oh, Miss Helen, I've already spoken on Miss Miller and I've sent the plea paperwork.
On Miss Miller?
Yes, on position 16.
Okay.
Judge and then send it back to her.
Okay, so Ms. Rosenhuber, we're just waiting on your client, Mr. Batson.
Yes, Judge, and I don't anticipate that we will see.
Okay, all right, in that case, Ms. McCutcheon, if I can beg your indulgence while we're waiting.
Yes, Judge. Mhm.
All right, Ms. Rosenhuber, on your 3 cases from the 9 o'clock calendar, which was the status calendar, position 1, Batson, Demetrius Batson has failed to appear, has failed to engage. This is going to be a, what?
Bench warrant, Your Honor.
Right, Mr. Batson would have to, this is going to be what, simple battery against officer. This is going to be $1,000 surety bond. And once you let him know, he needs to show up in court and surrender. And we can either take him off as a SAP calendar, or if he makes bond, he needs to make sure that he appears via Zoom with competent devices.
Yes, Your Honor.
All right, so Ms. Redden, this will be a bench warrant of position number 1. Position 6 and 7, position 6, Mr. Griffin and Mr. Hamer Hodges will both please. So where's that? Okay. At the 1:30 calendar, Ms. McCutcheon, your position number started from which case?
Mine started, let me go back to the calendar, Judge. You were halfway through the calendar. So mine would have started at around position 13, I believe. 14. I started at position 14.
Okay. So you didn't do Sean Francois?
No, Your Honor.
Okay. So Jermaine Kelly is going to be further, position 14 is further notice for a jury trial. Position 15 is further notice for a jury trial. 16, Alexis Miller is, was a, well,
it's going to be a plea.
There's going to be a plea, okay.
Yes. Mhm.
Position 17 was a plea. Position 18 is reset for jury trial, Preston. Position 19, Randall, is reset September 8th, status candidate pending an MH evaluation. Position 20, Reed, was a plea. 21, Sterling, is reset to final plea calendar September 8th at 1:30 p.m. Position 22, Sterling, is reset to September 8th, final plea calendar. Position 23, Walker, was a plea. 24, Wharton, was a plea. 25, Williams, is Mr. Haddad's case, and that's going to be further notice for a jury trial. Position 26, Wembley, was a plea.
Yes, Judge.
And Your Honor, I've emailed that paperwork for Ms. Miller to Ms. Redden.
Well, I actually, I sent it to yourself and Miss Redding and the state Orca email address.
That's fine. We're just waiting for it to
Okay.
be written. And then as soon as I have it in my hot little hands, I will call the Miller case. All right. Miss Riley, are you still working on something?
I believe she's filling the paperwork out for position, was it Mr.
Yes,
Dossier?
Number
Yes.
5, position.
Okay,
And I think that's the last thing I'm waiting on, Judge.
all right. Thank you. All right, Alexis Miller. Okay.
She may have stepped outside, Judge,
That's one.
or the bathroom.
All right. Just on a break, brief bathroom break. And Ms. McCutcheon, we are just on Miss Alexis Miller, it will just be on the DUI charge and everything else is null pros, correct?
No, Judge, it's, go back to that one, Your Honor. She's charged with, it would be a plea to the DUI and a plea to the possession of open container.
We're not talking about Ms. Ponder.
I'm sorry, yes. No, Judge, it would be a plea to the DUI and the state would move to null pros the failure to maintain lane, yes. I apologize, I was looking at number 17, we're on number 16 now. That's your understanding, Ms. Helen?
That is our understanding.
Considering the hour, you know, I'll take that. Okay. Whenever Ms. Miller is ready, she can come forward to the podium.
And she's here, Judge.
Okay. All right, this is State versus Alexis Sharmaya Miller, 21 CR 005350F. Ms. Miller was originally charged with DUI driving under the influence of alcohol less safe and failure to maintain lane from a May 30th, 2019 incident. Ms. Miller, you've been advised of your right to remain silent and your attorney is Ms. Helen. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. All right, Ms. McCutcheon, you may proceed with your recommendation.
Yes, Your Honor. On a plea to one count of driving under the influence of alcohol less safe, the state expects the evidence would show this would be a first and 10 DUI. The state would recommend the 12 months to serve 10 days. Of course, the court can reduce to 24 hours. So 12 months to serve 24 hours, credit for the time already served, balance on probation. While on probation, the defendant pay a $300 fine, perform 40 hours of community service, complete the risk reduction program, undergo an alcohol and drug evaluation and treatment as determined appropriate, complete one victim impact panel. The state will move to null pros the failure to maintain lane.
All right.
And
yes, Ms. McCutcheon.
Yes, for the factual basis, Judge, had the case gone to trial, the state would have expected the evidence to have shown that on May the 30th of 2019, Georgia State Patrol trooper was traveling north on Piedmont Road near East Wesley Road in Fulton County, observed a black Mercedes traveling at a high rate of speed. The officer visually estimated the speed to be 55 miles per hour in a posted 40-mile-per-hour zone. The driver approached the officer. The officer confirmed the speed with the rear direction antenna of his vehicle, that confirmation being 54 miles per hour in a posted 40-mile-per-hour zone, and also observed that the driver was failing to maintain her lane of travel as she passed the officer's vehicle, and she struck the right side curbing on more than one occasion as the officer observed her driving. The officer initiated a traffic stop, made contact with the driver, who was identified as this defendant, Miss Alexis Miller. The officer then, upon speaking with her, detected a strong and distinct odor of an alcoholic beverage coming from her breath. Her speech was slow, audibly slurred. She displayed red, watery, and bloodshot eyes. She advised the officer it was her birthday and she'd been out celebrating. The officer asked her to submit 2 field sobriety tests, to which she consented. Based on her performance of the field sobriety evaluations, as well as her voluntary submission to the portable breath test, which tested positive for alcohol, the officer determined that she was less safe to drive and operate a motor vehicle and placed her under arrest. Upon also upon searching the vehicle, incident to the impound of the vehicle, the officer discovered an open container of an alcoholic beverage.
But she wasn't charged with that.
Are you reading the correct fact?
Oh, no,
pattern?
I'm sorry, Judge.
Yes,
Judge, I'm sorry, strike that. Strike that, Judge. She advised the officer that she was drinking wine during the evening, but the officer did not find the beverage. So strike that, Your Honor. That was a misstatement. She advised the officer she'd been drinking wine during the evening. The officer did not find any indication of that in the vehicle.
Any other discrepancies, Ms. Helen?
Your Honor, and I will say, Your Honor, since this would be appropriate had the case gone to trial, the officer did read the implied consent notice for her blood. She eventually agreed, then later refused and stated to the officer, FUCKU and your test. And I believe when I read that, Judge, that may have gotten me off from the rest of the report. So it was a refusal, which would have been admissible at trial, refusal of the blood test. That completes my recitation. Do you stipulate to a factual basis for plea of driving under the influence of alcohol less safe? Ms. Helen?
We do so stipulate. I do believe a refusal is not admitted.
Of the blood test, a refusal of the blood test would be admissible.
Judge, we're not going to dispute.
Do we need to litigate Elliott right now?
No,
Okay,
Judge.
So I understand you both can stick to your positions on that, but for purposes of plea, it doesn't have a place right now.
Understood, Judge.
Yes, Ms. Helen, any other discrepancies in the narrative?
Not so much discrepancies. We just have Ms. Miller here. This case was 4 years ago. Currently, Ms. Miller is a countrywide traveling motivational speaker on substance abuse. For this topic, Judge, has had no arrest since this incident, no arrest about substance or any substance abuse, Judge. And so we're asking for all of the conditions. We're asking for non-reporting once these conditions are completed. She's a proud mom of 2 twin 11-year-old boys. And again, Judge, she does provide to the community and she is out in the community helping. She also is present here with her mom, Judge. So she does have strong family ties. I do not believe that we have an issue of possible reoffending. So Judge, we're asking for that non-reporting.
Any objection, Ms. McCutcheon, to non-reporting after completing the litany of conditions?
Your Honor, no. As long as the probation does not terminate, the state is not opposed to non-reporting.
All right, that's granted. Anything else, Ms. Helen?
No, Judge. Yes, Judge. The last thing, this is her first DUI. We're asking for first time DUI conviction affidavit, and we'd actually like the opportunity to fill that out today.
Well, I just got one right here. I don't know if I've got another one. So unless
It's right here.
Ms. Redden is way ahead of us. That's granted. Anything else?
No, Judge. Oh, and she'll be on probation until she can get these conditions completed. Can I have at least the first 3 months of the probation fees waived, Judge?
She's working. You said she was a.
She is working, Judge. She is working, Judge, but.
Denied.
Understood, Judge.
Anything else?
No, Judge.
Okay. Ms. Miller, have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained to you that if you decide to close this case out with this plea today, there is no right of appeal and there's no trial? Yes. You don't go back into a courtroom to face your accuser, examine witnesses, challenge the evidence brought against you, present any defenses if you choose to do so, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to one count of driving under the influence of alcohol, let's say?
That's him.
Repeat.
That's him.
I'll accept your guilty plea. Your sentence is 12 months, serve 24 hours, credit for time served, 24 hours. The remainder of the time you'll be on probation. Your first visit will be next Thursday before 3 p.m. at 132 Mitchell Street. I'll grant you the affidavit of first conviction. You will also be assessed a $300 fine plus any court costs and surcharges. You need to complete 40 hours of community service, which can be done at any nonprofit 501c agency, which is not a school and not a religious organization. You must submit to an alcohol and drug evaluation with a qualified provider and submit yourself to any treatment that may be recommended or required by the evaluator. You also attend and complete a risk reduction program and one victim impact panel. The failure to maintain law charge is null pros, in other words, closed out. Once you've completed all the conditions for DUI, your probation may be non-reporting. And I think I've already mentioned the affidavit of first conviction. Any questions?
Yeah.
All right, that completes that. I have the affidavit of first conviction for Ms. Ponder ready, but we'll have to wait for Ms. Miller's, all right? Where we go for Ms. Miller, all right? The only other matter we are waiting on is Mr. Dosters.
And I'm just making sure I have the plea paperwork.
Ms. Rosenhuber, are we completed with all your cases?
Yes, Your Honor. I'm just sticking it out with Miss Helen.
I appreciate that. Thank you.
And Judge, is that Miss Riley sending that? I haven't received it for Mr. Doster.
It was sent to Ms. Redden.
It's right here.
Oh.
Board.
And Your Honor, I know that the court and Madam Clerk are multitasking, but I just emailed the null pros order for Ms. Miller on the failure to maintain lane. And I copied you as well, Ms. Helen.
Understood.
And my apologies to the court when of course, when you have multiple reports up and you're reading the factual basis. So that was entirely a misstatement in my error in reading the misstating the open container in the last case.
Miller's numbers. Ms. Riley, we've gone over the calendar. Did you want to, well, we'll do it after the DOSCR hearing, okay?
Yes, Your Honor.
Okay. This is State versus Jawara T. Dosker, position number 5 in the 1:30 Orca calendar for today. Case number 21 CR 005557F. Mr. Doster was originally charged with driving under the influence of drugs, possession of marijuana less than 1 ounce, impeding traffic flow, and driving under the influence of alcohol less safe. Mr. Doster, you've been advised of your right to remain silent, and your attorney, Ms. Helen, is standing right next to you. For purposes of this plea, may I place you under oath? Do you solemnly swear and affirm that the information and testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Riley, we are just proceeding with the DUI less safe and the impeding traffic flow. Would that be correct?
That is correct, Your Honor.
So we're going to, what's the state going to do? Null cross counts 1 and 2?
Yes, Your Honor.
All right, thank you. So what's the recommendation for counts 3 and 4?
Count 3 is 12 months to serve, 24 hours, credit for time served, 24 hours, balance probated, a $300 fine, 40 hours community service, alcohol and drug eval, and any treatment that is recommended, risk reduction, 1 victim impact panel. Count 4 is 12 months probation concurrent to count 3.
All right. And Ms. Helen, does your client accept these terms?
He does, Judge, and we would ask this court to accept the plea as negotiated.
All right. And do you stipulate to the factual basis, venue, and ID?
We do so stipulate, Judge.
Thank you. Mr. Doster, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And has anyone promised you, induced you, or forced you to take this plea?
No, ma'am.
And in taking this plea, have you gone over the documents with your attorney?
Yes.
So you understand that you'll be waiving your right to a trial, to confront your accuser, examine witnesses, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
How do you plead to 1 count of DUI less safe?
Guilty.
And how do you plead to 1 count of impeding traffic flow?
Guilty.
Your sentence is going to be 12 months to serve 1 day, credit for time served 1 day. You'll be placed on probation. You report to probation next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you pay a $300 fine plus any costs, court costs and surcharges. Complete 40 hours of community service with any nonprofit agency, which is not a school and not a church. You will submit to an alcohol and drug evaluation with a qualified provider and submit yourself to any treatment that's recommended or required. A risk reduction class must be completed by you, as well as attending 1 victim impact panel. Your probation officer will explain to you these programs and which are acceptable.
Okay.
With regards to the impeding traffic, that will be a 12-month probation, which will run concurrent to the DUI sentence. Do you have any questions about these, the sentence?
No, ma'am.
All right. Remember to report to probation next week. That concludes your case. Thank you.
Thank you, Judge.
Ms. Redden, here's the plea form, Mr. Doster. All right, Ms. Riley, I'm just going to go over. Ms. Helen, do you need to be here when I go over the cases?
Yes, Judge, I'm about to come back, Your Honor.
Okay. Okay. For Ms. Riley's cases from the 1:30 calendar, with regards to position 1, Alvarado, that was a plea. Position 2, Andrews was a plea. Position 3, Bagley was a plea. Position 4, Cherry was a plea. Doster was a plea. 6, Elliott is reset to a final plea calendar on September 8th at 1:30 p.m. Alan Lightcap is counsel of record, should be counsel of record. He should have filed an appearance. Position 7, Daryl Ford was a plea. Position 8, Nigel Fox, is a reset to September 8th, 2023 at 9 a.m. along with his 2 other open cases. Position 9, Miss Jalen Gill did not show up, but we've reset the case to September 20th at 9 a.m. for a must appear in person with regards to an update on compliance with diversion.
I'm sorry, Your Honor. I thought that was, he must appear via Zoom because he's a college student out of state.
Oh, that's right, that's right. I need to write larger. Must appear via Zoom. You're absolutely right. Position 10, Jimmy Givens, is a further notice for a jury trial. Case management order has been signed. Position 11, Irby, is reset to after October 2023. I believe he is deployed at the present time.
Yes, Your Honor.
12 and 13, Jean-Francois, is a final reset to September 8th at 1:30 p.m. final plea calendar. Position 14, I think, was Ms. McCutcheon's cases onwards.
Correct.
One over those.
Yeah.
I believe that concludes the calendar. Yes?
Yes.
All right, everyone, you enjoy the weekend starting now.
Yes, you as well. Take care. Good to see you.
Bye-bye.
Bye-bye.